a driven, talented, smart young lady, the captain of a college's cheerleading team, killed in a shooting during a drug deal. Maybe we will find out as we watch the trial of defendant Khalil Oglivie, one of the 4 people involved in that drug deal gone wrong. He is charged with the first-degree murder of MaKayla. Today, we hear opening statements and the questioning of 6 state witnesses. Our prosecutor is the well-known Georgia Cappleman, and Khalil is defended by a local prominent defense attorney, Nathan Prince. Here are the individuals involved in the January 26, 2022 drug deal that resulted in MaKayla's death. MaKayla Bryant, our victim, was a 22-year-old psychology graduate student who studied at Florida A&M University. She was also the captain of the cheerleading team, treasurer of the Phi Sigma Theta National Honor Society, and a member of the Delta Sigma Theta sorority. She was with Precious Charlton, a 23-year-old bachelor student at Florida A&M University, who was dating MaKayla at the time. The defendant, Khalil Oglivie, was 26 years old and was with Brian Knight, his buddy, who was unemployed. The two would often smoke together. Thus, the pairs met during the botched drug deal. So, let's watch the trial.
Have a seat. Good afternoon. Good afternoon. Thank you, folks. Afternoon. So, let me get the computer going here just a second. All right. So we are here in case number 2022 CF 288, State of Florida versus Khalil Oglivie for trial. Ms. Cappleman, is the state ready for trial?
Yes.
Very well. Mr. Prince, is Mr. Oglivie ready for trial?
Yes, sir, Your Honor.
All right, very well. So, okay. So, all jurors are present. I'm told we've had one juror who expressed some concern about sort of the gravity of the responsibility, so we're going to bring that juror in and just do an inquiry, make certain that we don't have any problems in the future. For those of you who are here to observe the trial, I just want to welcome you to the Second Circuit and thank you for your presence. It's not my courtroom, it's your courtroom as much as it's anybody's courtroom. And it's an open public trial, which means that that's part of the court's fundamental accountability and transparency, that anyone who chooses to can hear the testimony in the case, see the evidence as it's presented. That being said, we all have our roles in the courtroom, and the jury's role has to be to give close attention, uninterrupted attention to the evidence and testimony that it's presented. And anytime when we're trying to resolve something as serious as an alleged homicide, the testimony and evidence can be upsetting. It can be emotional. And I have to insist that we don't do anything, neither me or the advocates or the observers, anything to distract the jurors' attention from that crucial role that they have. They're here to do us this service of resolving this case for us. And so please, if at any time you're concerned about your ability to maintain that role as the neutral observer, the observer who does not distract the jurors, if you're worried that your emotions might get the better of you, I'll just ask you to step out. If I see it happening, I'll send the jury out, and we'll make certain that the jury is not distracted from its responsibilities. I know that you will honor the jury's service by maintaining your silence and not distracting them from their work. All right, so should we bring, where's Sprayberry? Should we bring Juror Hall in? Yes.
And I've got to shut you off. You probably do that, so there's no minutes.
Okay, that's just fine. Ms. Cappleman, Mr. Prince, any preliminary matters that we need to, any other preliminary matters we need to attend to?
Judge, may I have permission to use State's Exhibit 1 during opening the identification photo?
Any dispute?
No, Your Honor.
Of course, that's fine.
Nothing else from the state, Your Honor.
Mr. Prince?
I was just going to put on the record, Your Honor, that Ms. Cappleman and I have coordinated, and I don't have any objection to any of the exhibits that they intend to introduce. So she's going to kind of speed through the foundation and predicate to that and introduce it as she goes, but I have no objection to any of the state's exhibits.
Very good. Thank you so much for that, Mr. Prince. I appreciate y'all's professionalism.
Also, since we're waiting on her, I don't remember if we put it on the record at docket sounding or not, but there was never a formal offer in this case. We did have some discussions back and forth, but never materialized anything, so there was never an offer to reject, and Mr. Oglivie never asked me to extend a specific offer to the state.
All right, fair enough. Take your time, Mr. Ogilvie. You're fine.
Yes, sir.
So for the media, my only request is that you don't break down while there's a witness on the stand. If you need to break down, wait until we're changing the witnesses out. And I'd ask that you not show any of the jurors' faces. Ms. Cappleman, were you going to play any video during your opening at all? All right. All right. So, record will reflect Mr. Oglivie's present, fully dressed out, and not in any kind of restraints. So, Ms. Cappleman, anything before we bring juror 9, which is Ms. Lynn Hall, in?
No, Your Honor.
All right, we'll go ahead and bring her in, Deputy.
Jury in the court.
Thank you, Ms. Hall. Come on in, have a seat anywhere. Y'all can sit down, it's okay. Be seated, everyone. You can just sit down wherever you're comfortable, Ms. Hall. Thank you so much. You're not in any trouble or anything. So, first of all, thank you for being back here and on time and all of that. Ms. Sprayberry, the clerk, told me that you were expressing some worries and concerns about your jury service, and I thought I'd give you an opportunity to tell me about it, and maybe I can respond in some way that would be meaningful to you. If there's anything you want to discuss, you don't have to say anything, but if there's anything you want to talk about, I wanted to give you that opportunity.
In front of everybody?
In front of everybody, yes, ma'am. We can do it in a little bit more privacy if you want. You want to do it in a little more privacy? Come on, we'll go into the jury room store. Mr. Oglivie, you can come with us. Come on.
Yes, sir.
You can if you'd like.
Do you want to go to the record?
Yes, ma'am. Yes, ma'am. If
Second session.
Be seated, stay seated, have a seat. Oh, thank you so much. Excellent. All right, so we're back on the record. State of Florida versus Khalil Anthony Oglivie, 22 CF 288. Mr. Oglivie is present. Ms. Cappleman, anything before we bring the jury in? Mr. Prince, anything before we bring the jury in? Whenever you're ready, Deputy.
Jury in the court.
Thank you, folks. Come on and find your seats. Thank you so much. Afternoon. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. All jurors are present in the courtroom. Please be seated. Be seated, everyone. Have a seat. Thank you, folks. All right, so this is the case of the state of Florida versus Khalil Anthony Oglivie, 22 CF 288. Ms. Cappleman, is the state ready for trial?
Yes, Your Honor.
Mr. Prince, is Mr. Oglivie ready for trial?
Yes, sir, Your Honor.
Very well. So let me just make sure I got everybody where I expect them to be. Juror number 1, Mr. Mears is present. Juror number 2, Ms. Ludgate is present. Juror number 3, Ms. Shively is present. If I pronounce that even close. Juror number 4, Ms. Lakia? Close enough. Laquia. Thank you, Ms. Laquia. Ms. Minnick, present. Mr. Wood is present. Ms. Rentz, Mr. Rentz is present. Ms. Merck is present. Ms. Hall is present. Mr. Young, Mr. Lee, Mr. Lazara, Ms. Lazara, Ms. Avery, and Ms. Register. All jurors are present. The seat that you're in is the seat that you'll occupy throughout the trial, so I'll just ask that everyone stay in their same seats throughout the trial. I'm going to read you some preliminary jury instructions. You'll see at the end of the trial, I'll do a final set of the jury instructions, and I'll make a written copy for each of you. Each of you will be able to read along with the final charge and take those instructions back with you for your reference during your deliberations. Those final instructions will include these preliminary instructions that I'm about to read, plus you've already heard quite a few of these instructions during jury selection. But you don't need to worry about taking notes on these preliminary instructions because you'll have them in writing at the end. Mr. Prince, let me just get you to approach just briefly after that. Do you want to read the silence?
Yes, sir.
All right, thank you. Thank you. All right, and before we do that, one last thing that you'll need to do, we're going to administer the oath. This is the trial oath, the oath by which you accept the responsibility of resolving the issues in this case based on the evidence presented and the law in which I will instruct you. If you'll all please stand, raise your right hand, the clerk will administer the oath.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and evidence? If so, say I will.
Very good. Please be seated. I'm going to read you the preliminary jury instructions now. State of Florida versus Khalil Anthony Oglivie. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Khalil Oglivie. This is a criminal case. Khalil Oglivie is charged with the crime of first-degree premeditated murder. The definition of this charge will be explained to you later. The state's charging document, which is called the indictment, is not evidence or proof and is not to be considered by you as any proof of guilt. The indictment is the charging document. It's the accusation you're here to resolve. It is the judge's responsibility to explain the law to you. It is your responsibility to determine if the state has proved its accusation by evidence beyond a reasonable doubt against the defendant in accordance with the law that I provide to you. Thus, the responsibility of the jury and the responsibility of the court are well defined and do not overlap. This is one of the fundamental principles of our system of justice. Sometimes we call the jury the judge of the evidence or the judge of the facts. I'll talk to you a little bit more about that in just a moment. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say during the opening statement is not evidence, and you're not to consider the opening statements to be evidence or proof in the case. After the opening statements, witnesses will be called to testify under oath. The witnesses will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. It's the testimony of the witnesses and the exhibits that are entered in evidence that make up all of the evidence in the case. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then make their closing arguments. After the closing arguments, the court will conclude with final instructions, and you will then retire to consider your verdict. You must not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence. The instructions on the law by the judge, the argument of the attorneys. Until that time, you must not discuss the case amongst yourselves or with anyone else. Your verdict must be based solely on the evidence or lack of evidence and the law. I again instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. Do not do any research about the case or look up any information about the case. Should you become aware of any violation of these rules at all, notify court personnel of the violation. They'll bring it to my attention, and I will take care of it. During the trial, the court may take recesses. You'll be permitted to separate and go about your personal affairs. During recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. In the unlikely event that anyone attempts to say anything to you or in your presence about the case, tell the person you're on the jury trying the case, tell them to stop talking to you. Should a person persist in discussing the case in your presence, leave at once. Immediately report the matter to the court deputy who will advise me. If the lawyers see you outside of the courtroom, they will not acknowledge your presence. It's not that they are being discourteous. They're trying to avoid the appearance of any improper contact with you. So please, don't take offense if the lawyers don't acknowledge your presence outside of the courtroom. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. You may use these devices during recesses, but not to find out any information about the case. or to communicate with anybody about the case or the people involved. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, make sure your phones or other electronic devices are turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside of the jury room. You will not be permitted to have cell phones, computers, or other electronic devices in the jury room during your deliberations. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay, and a contact phone number will be provided to you for that purpose. The case must be tried by you only on the evidence presented during the trial, in your presence, in the presence of the accused, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to the case or the people and places involved. You must not visit places mentioned in the trial. You must not use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I must stress again, just as you must not talk about the case face-to-face, you must not talk about the case using an electronic device. You must not use phones, computers, or other electronic devices to communicate about the case in any way. Do not send or accept any messages related to the case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on a social media website, chat room, or blog. These rules are imposed because jurors must decide the case without distraction, only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the judge has no way to make sure that the information you obtain is proper for the case. The parties have no opportunity to dispute or challenge the accuracy of what you might find, contrary to the right of each party to ask questions about and challenge the evidence presented and considered by the jury. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. A juror who violates these restrictions jeopardizes the fairness of the proceedings. A mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. I hate saying this. If you violate these rules, you could be held in contempt of court, face sanctions such as serving time in jail, paying a fine, or both. Never in 23 years have I had to do that, and I don't expect that I'll have to do that this time. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their responsibility to make all objections they feel are proper. If an objection is made, you must not speculate on the reason why it is made. Likewise, if an objection is sustained or upheld by me, and I tell a witness, don't answer that question, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. An objection is really the lawyer's way of informing the judge that there's a legal matter for the judge to decide. Remember, legal matters are for the court, for the judge, unless I give you a specific instruction. Remember, I'm the judge of the law, you're the judge of the evidence. If we do work outside of your presence, you're not to speculate about the work that we're doing outside of your presence. If there's something that you need to be instructed on, I'll give you a specific instruction. During the trial, it may be necessary to confer with the attorneys outside of your hearing to discuss matters that require consideration by me alone, legal matters. It is impossible to predict when such a conference may be required or how long it will last. Should conferences occur, they'll be conducted so as to consume as little of your time as is necessary for a fair and orderly trial. Taking notes, the law of taking notes. If you would like to take notes during the trial, you may do so. You are not required to take notes. You each have a notepad and pen to use to take notes if you wish. Your notes are for each juror's personal individual use, so don't take the notepads from the courtroom. When we leave the courtroom for recesses, leave your notepad in your chair so we don't mix up your notepads. During recesses, the deputy will safeguard your notes and make certain that we return them to you when we reconvene. After you've completed your deliberations, the deputy will deliver your notes to me to be destroyed. No one will ever read your notes, including me. The only reason he gives them to me is so I can make certain that nobody ever reads your notes. Your notes are for you alone. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. You don't need to make a transcript. We have a court reporter for that. How the witnesses answer the questions, their facial expressions, their demeanor on the witness stand can be as important for some of the things that you'll have to consider as the words that the witnesses use. So it's important that you don't get so involved in taking notes that you become distracted from the proceedings and miss the trial. Whether or not you take notes, your notes should be used only as aids to your memory. You should rely on your memory of the evidence and not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight in your deliberations than each juror's memory of the evidence. The attorneys may at this time, if they choose, give their opening statements. Remember that what the lawyers say during opening statement is not to be considered by you as proof or evidence in the case. The opening statements are intended to help you follow and understand the evidence as it's presented. So I ask that you give the attorneys your close attention. Ms. Cappleman, do you wish to be heard?
Yes, Your Honor. May it please the court.
Very well.
Members of the jury, good afternoon. This is MaKayla Bryant. The evidence in this case will show that on January 26, 2022, this beautiful young woman was tragically killed at the hands of this defendant, Mr. Oglivie. The evidence will show that earlier that day, a suspect used an untraceable number to set up a drug deal. Not with Ms. Bryant, but with her girlfriend, whose name is Precious Charlton. The deal was for $650, which was to be exchanged for a quarter pound of marijuana. A relatively large amount for Ms. Charlton. It wasn't the first time she'd sold marijuana, and it wasn't the first time she'd sold a quarter pound. But it was relatively unusual to sell that large amount. Although the communication was done through text messaging through an anonymous app on the phone, the suspect indicated during the chat that he knew Ms. Charlton was a female. He referred to her as Mom. And he would have no way of knowing that through her profile name. So she thought nothing of it at the time, but in hindsight, it does appear that this suspect knew more about her, maybe, than she knew about him. Ms. Charlton, the defendant armed himself with a 9mm firearm, and he showed up at the appointed location. It was a parking lot of an apartment complex on the south side. The defendant parked in such a way that the women would not be able to see where his car was, or they couldn't see where his car was. And as such, they would not be able to identify what type of vehicle he was in later. Then he and his friend exited his vehicle and approached the two women who were seated in their car, backed into a parking spot in that complex. The women had arrived in Ms. Bryant's silver Lexus SUV and backed into the spot, as I said, and they texted through this text messaging application on the phone that they had arrived. Ms. Charlton was driving, so it was Ms. Bryant's vehicle, but Ms. Charlton was driving, and Ms. Bryant was the front passenger. Because these two were a couple, Ms. Bryant would sometimes ride with Ms. Charlton to do these deals. Because they were both petite young women, both women had a practice of carrying and displaying a handgun during these drug transactions. They each had a gun that they would put on their laps routinely during these deals. And the practice was intended to secure them, to provide insurance for them against the possibility of being robbed or harmed doing drug deals with strangers. But as the evidence will show you on this occasion, it did not work. As the two men approached the two women in the car, Ms. Charlton noticed that one of the men was masked. He had something covering his face. But we're in January of 2022, close enough to COVID times that did not alarm her in any way that he had a face covering. So we have two women seated in the car, two men approaching. They both approach on the passenger side where Ms. Bryant is seated, and Ms. Bryant partially rolls down her window to interact with the two men. The masked suspect is up closer, and his friend is kind of hanging back a few feet behind him. Ms. Charlton, the driver, notices that this second guy is kind of hanging back, and she makes eye contact with him several times throughout this incident. Some discussion was had between the parties about the drug deal. Was it really a quarter pound? We don't think it is. We want you to weigh it. The suspects hand a scale into the women, asking them to weigh the drugs. But before the weighing can be accomplished, before there's any exchange of cannabis or money, the masked man makes a statement, which Ms. Charlton understood in that moment to change this incident from a drug deal into something else, a robbery. He said, now this is how this is about to go. And it was the way he said it, not just the words that were said, that let her know something had changed. Everything had changed. He spoke these words in a whole new tone, a commanding tone. And that's what really alarmed her. When the statement was made, Ms. Charlton had glanced down at her phone, kind of thinking, this is taking too long, right? And she's wondering, like, do these guys even have the money to do this deal? And at the statement made by the masked man, she looks up. And when she looks up, she sees that his arm, that suspect, the one with his arm, not the friend that was hanging back, his arm is now inside the car. And again, it's on Ms. Bryant's side. And Ms. Bryant is wrestling with the guy over a firearm. Initially, Ms. Charlton thinks, oh, he's reached in and grabbed her gun, and now they're fighting over control of that weapon. And she actually has some thoughts like, you know, I don't know if the gun's really ready to fire, like maybe he won't be able to fire it. And there's just this few long seconds where this struggle is occurring, and Ms. Charlton is processing what's happening, and Ms. Bryant's fighting for her life, right, to get that gun away from this guy. It's not until later that Ms. Charlton will realize, oh, he had his own gun, because he ended up leaving the gun behind in the car after this incident. And when she gets MaKayla Bryant out later, she sees another handgun that isn't either one of their two handguns. A gunshot rings out during the struggle, and Ms. Charlton hits the gas. They're backed into that parking spot. They're already in drive. She hits the gas, and as she pulls away, the shooter continues to hang on to the car. Ultimately cracking the window. Remember I said it was kind of partially down, maybe a third to two-thirds of the way down, and so he's in that window holding on to the vehicle, and the window actually cracks. After pulling away from the suspect, Ms. Bryant tells Ms. Charlton, I've been hit, I've been shot. And tragically, those are the last words that Ms. Bryant will ever utter to anybody. because after she's taken to the hospital, she quickly passes away. The bullet entered her chest, it passed through her lung, and severed her spine with catastrophic consequences. In a panic, Ms. Charlton calls 911. She's trying to get to the hospital. She's hysterical. She's having a hard time figuring out how to get there. She ultimately does arrive at the hospital. She pulls right up to the first entrance that she sees. Doctors and nurses have been alerted that they're on the way throughout this 911 call, so they're there. They come out and they assist Ms. Bryant, or try to. They begin rendering aid in the form of CPR. You'll see a small snippet from one of the first responding officers who arrives, so that you can see sort of what he sees as he gets there with Ms. Bryant being worked on there in the parking lot or driveway of TMH. Ms. Bryant is taken into surgery, but the damage is too catastrophic to help her, and she passes away in the operating room. The medical examiner would later rule her cause of death to be a homicide. When MaKayla Bryant was first removed from the car at the hospital, as I told you, Ms. Charlton notices, there's another gun in here. This has got to be the guy's gun. This is the gun that shot her. And she alerts law enforcement to that, and they're able to collect the gun into evidence. The gun is processed for DNA evidence. You're going to hear the 911 call made by Ms. Charlton that day, and you will have no doubt that what you are hearing in her voice is sheer terror. What you will not hear is the 911 call from this defendant calling to report that he has done a shooting in self-defense. You won't hear that call because that call doesn't exist. The DNA testing on the firearm that was used to shoot MaKayla Bryant revealed that this defendant's DNA is present on the firearm. Also, his DNA is present on that scale that I told you to weigh the drugs that was offered to the women at the scene before the shooting. At the conclusion of this evidence, I will ask you to render a verdict that holds this defendant accountable for his actions that day. And that will be a verdict of guilty as charged for first-degree murder.
Thank you, Ms. Cappleman. Mr. Prince, do you wish to be heard?
Yes, sir. Thank you, Your Honor. Ms. Cappleman began her opening statement by telling me that we're here because the beautiful young woman on the screen behind her was killed at the hands of this defendant. And that's true. That's not an issue there. What's at issue is whether the conduct was justified. And what you're going to hear over the course of the trial is a whole lot of evidence about a lot of other things, but almost none that has to do with that question right there. I think it's helpful at the beginning of the process here, an opening statement, not just to tell you what the evidence is and what I expect to come out in the way of testimony and exhibits that may be admitted, but also to just remind you of some of the things you're going to hear from the court at the end of the trial. Because that's what forms the prism through which you view all the evidence in the case if you're following the court's instructions. As you recall from jury selection, the court instructed you that the state has the sole and exclusive burden of proof. The defendant doesn't have to convince you of anything. Nothing. He doesn't have to prove his innocence. He doesn't have to make you believe him. We don't have to do anything. We have no burden. The state, on the other hand, their burden is not merely to introduce a version of the events, which could be true, or the most believable, but a version of the events which establishes beyond a reasonable doubt, as defined by the court, that this defendant committed the offense of first-degree murder, as he's charged. There will be almost a full day of testimony tomorrow from witnesses from the state who have, as I indicated, a lot of information to give, but almost none of that information, is based on the order of witnesses, none of that information will bear on the actual question in this case, which relates to justifiable use of deadly force which the court may instruct you about, if he deems appropriate at the end of this trial, and about the defendant's intent in the case, which is an element of the offense that he's charged with. All those things are important to keep in mind as we're going through the evidence. It's important to remember whose burden it is. It's important to remember what the burden is. Proof beyond a reasonable doubt. The reasonable doubt being defined as the court holding jury selection as a doubt which arises from the evidence or a conflict in the evidence or a lack of evidence. A doubt that is therefore not imaginary and not speculative. So that's the prism through which you view the evidence. I think it's also helpful at the beginning of the trial to tell you now what some of the factors that the court will give you at the end of the trial to consider witness credibility, so that as you're hearing the testimony, you can kind of check those boxes in your mind, write a notepad. So the court will tell you to consider things like, did the witness have an opportunity to see and know the things about which they're testifying? Did the witness seem honest and straightforward? Did the witness have an interest in the outcome of the case? Did the witness's testimony agree with the testimony of other witnesses and the other evidence introduced in the case? Did the witness at some time make a statement that was inconsistent with the testimony they offered here in court, and whether the witness is a convicted felon? Those are all factors that the court will give you at the end of the trial to consider each of the witness' credibility. Understanding that, I think it's important, too, for me to just right up front answer for you the question of why are we here? Why are we here? We're here because Precious Charleston, an inexperienced drug dealer who wasn't particularly good at it, chose to put her girlfriend in a terrible situation, chose to bring her girlfriend to a drug deal and arm her girlfriend with a weapon which nobody disagrees was displayed throughout the entire interaction between these people. Ms. Charlton herself will admit that to you. So here's kind of how the testimony is going to go as it relates to Ms. Charlton. That she was a drug dealer, and she'll tell you how we got to this point, how she ended up at the apartment complex where the shooting took place in this case. And what she'll explain to you is that, as Ms. Cappleman indicated, on this particular date, she gets a text message through an app. She gets the text message through that app because she advertises the products that she sells as a drug dealer on that app. It's not uncommon for people to just contact her out of the blue. You'll hear that she found the address or where to meet them at and drove there. She drove there with her girlfriend in the vehicle with her. Her girlfriend, Ms. Bryant, was the image that you saw on the screen behind Ms. Cappleman when she gave her opening statement. So they roll up, right? They park, and Ms. Cappleman says that the defendant parks surreptitiously in an area. No, he doesn't. You're going to see the videos. He parked right in the same apartment complex parking lot between the two buildings, same place she did. Okay? He's just farther down because they were there to see a buddy. There's two guys there. All right? It's the defendant and his friend Brian Knight. They've known each other for about 6 months. They had no plans to meet up that day, but they happened to. They met up at a convenience store by happenstance called Tony's. When they ran into each other there, they said, hey, you want to go get some weed and go over to our buddy Tony's house? Maybe I'm getting the Tony confused with the gas station. Regardless, they were going over to a buddy's house at the apartment complex where the drug deal took place. And they were going to go hang out with him and smoke some weed there. So they get on the app, and what you'll hear, this is another thing that, perhaps the person who contacted, Miss Charlton in this case knew who she was, and this was some sort of setup because she was a female drug dealer. They didn't even have a plan to smoke that day, all right? But normally, when these two go to get weed together, it's happened probably 10 times, 12 times with her during the course of the trial previously to this. Normally, they have a guy that they get from. And normally, it's Mr. Knight, who was present with the defendant, who arranges that. And there won't be any dispute in this case about the fact that it was Mr. Knight exclusively who arranged the drug deal here. It was all on his phone. It wasn't on the defendant's phone. The defendant never had any communication whatsoever with Ms. Charlton prior to meeting with the apartment complex on that day. And part of the reason that we're going to know this is how they all got there, this is how this went down, is because the police recovered video from Tony's gas station. They got video from other places, traffic cams and that, or wherever, and they see both the defendant's vehicle and Mr. Knight's vehicle driving to the apartment complex, parked in the apartment complex. Further down, yes, because that's where their buddy's apartment's at. But they're parked right there. It's not like they're trying to hide. So they get out, as indicated, when she arrives. There's a text message exchange between Mr. Knight and Miss Charlton right before they meet up with each other. He says he's coming out. They do get out. They walk up to her side of the vehicle first, from Charlton's side of the vehicle first, and she won't roll the window down, which is kind of weird. So she sends them around to the passenger side. All right? Miss Bryant, the decedent in this case, is sitting in the passenger seat. You're not going to hear anybody dispute, including Miss Charlton, that both she and Miss Bryant were armed with firearms, and those firearms were displayed at all times during this drug transaction. Those firearms were sitting right in their lap. Each gun had a round in the chamber ready to be fired. That's not because they came planning to rob. I'm not going to suggest that. You're not going to hear any evidence to that effect. That's not what they were there to do. They were there to do a drug deal, and they're just bad at being drug dealers, and that's why this death occurred. So rather than letting them in, she sends them around to her girlfriend's side and makes her girlfriend, who's not a drug dealer, do the conversation and interact with the potential customers here. And you'll hear that when ultimately, I'm going to jump ahead in time just for a second so you understand, you'll hear ultimately when she gives you her version of the events today, and the version of the events she's always given. You're going to hear that first, when she's interviewed by law enforcement, she told them she was just going to the apartment complex to meet her brother. Then you're going to hear she told them, oh no, she's going to the apartment complex to pick up or drop off Miss Bryant from work, which makes no sense whatsoever, but that's what she claimed. And she claimed during that version of the events that just some totally random guy who she didn't have any reason to think would be there, didn't have any reason to think that she would be there, didn't have a transaction set up with her, that he just comes up to the vehicle, leans inside, points a gun at both of them out of the blue. She assumes that he must just know she's a drug dealer because she does business in that area. These are all the different versions of the events that she gives prior to giving her final version of the events. So the defendant and Mr. Knight, his friend, are on the passenger side of the car dealing with Miss Bryant. And they start to get irritated because they won't let him get in the vehicle. And, Mr. Knight will explain this when he testifies in this case, and the defendant, who doesn't have any obligation to testify, will explain this to you himself when he testifies. That's a stupid way to do a drug deal. You don't stand out in the middle of a parking lot, especially in a parking lot where TPD regularly patrols because it's a high crime area, and do a hand-to-hand exchange in a clear bag with cannabis and hand money and drugs to each other. You don't hold cannabis and break it open and smell it in an open parking lot in the middle of the day with a bunch of people around and cops on the patrol all the time. That's not how you do it. What you do is you get in the vehicle, you weigh the stuff to where everybody can see it, and you exchange simultaneously. That's how every drug deal ever goes, unless you're inexperienced and don't know what you're doing, which is what happened here. So Miss Charlton won't let him get to the vehicle, and they're starting to get irritated because she won't show them the weight. She says, I just weighed it up a little bit ago. If you want to see the weight, give me the money first. And they're like, what are you talking about? We're not giving you the money before you can show us that it's the right weight. And that's important because ultimately what happens here is that the drug deal breaks down. Okay, the drug deal breaks down because she won't let them see the weight, and they're tired of dealing with her. So it wasn't that Mr. Knight was walking off to get a cup or anything else at that point. You'll hear some testimony about that. Either he or the defendant or both walked back and forth to their vehicle, which was in close proximity, to get a cup so that they could put cannabis in the cup and weigh it on top of the digital scale. But that was earlier in the interaction. When he walks off at the end, it's because he's done dealing with them. All right? And what happens right before he walks off, Mr. Knight walks off, is that Miss Charlton, who's had her gun in her lap the entire time, picks her gun up and starts waving it and kind of pointing it at them, saying, either give us the money or get the F out of here. Okay? And that's significant, and I want you to think about that testimony as we go through the trial today. Because for other reasons, I expect that the court will instruct you about one of the justifications for the use of deadly force being the imminent commission of a forcible felony, and I expect to tell you aggravated assault with a firearm is a forcible felony. But neither Mr. Oglivie nor Mr. Knight are going to claim that that was an aggravated assault, even though they probably could, because you know why? They weren't scared at that point. She wasn't saying, I'm going to shoot you, I'm going to rob you. She was saying, give me the money or get out of here. And so that's exactly what Mr. Knight does. He starts to walk off. Now, this part's real important. Miss Charlton says she looked away. She looks down at her phone. Okay, she looks down at her phone and hears somebody say, this is how this is fixing to go. All right? I want you to think about that testimony as you hear it. She's claiming this is a robbery setup. She's claiming she has a bad feeling about this. Nothing was weird about it until they made it weird, until they made it tense. There was a neighbor watching their initial interaction. All right, his name's Mr. Bassane. He sees both the defendant and Mr. Knight casually walk up to the vehicle. Doesn't seem to be any tension. He says it appears to him that they all know each other. They're just conversing. You know, I heard Ms. Cappleman say, you know, somebody's wearing a mask. I don't know where that came from because Ms. Charlton's never claimed that before. I hope she claims that in this trial because then there will be another inconsistency that I can point to. But the neighbor didn't say that. The neighbor just saw a bunch of guys in normal clothes go up and start talking to these girls where they were doing a drug deal. The part that I was telling you was important about the critical moment in this case, the only critical moment in this case, that Ms. Charlton says she looks away, she looks down at her phone right before the wrestling or tussling between the defendant and Ms. Bryant ensues. She says she assumes and she thought that he must have reached in and grabbed Ms. Bryant's gun. It's actually not Ms. Bryant's gun. It's actually Ms. Charlton's gun. Ms. Charlton gave it to her and armed her with it prior to the drug deal in this case. So she thinks that he must have reached in and grabbed the gun and that that's why they're wrestling. But she won't tell you she saw that. She can't tell you she saw that. She has no idea why he reached in the vehicle and what he grabbed when he reached in the vehicle because she wasn't looking. And that's the point of this case, that she doesn't have an opportunity to see and know the things that she's testifying about. She wasn't looking at him when it happened. She told law enforcement repeatedly, I thought he was committing a robbery. I thought he was about to commit a robbery. And when you hear her offer the explanation that, oh, he says this is how this is going to go, consider that in light of how you would normally expect a situation like this to play out. Use your common sense. You don't have to have been personally involved in a drug deal to know how a drug deal would go or to know how a robbery would go, right? There's not going to be testimony offered in this trial about these guys bum rushing them when they show up. There's not going to be testimony offered in this trial about a firearm being drawn as they're approaching the vehicle, ski masks on. It's not nighttime. It's middle of the afternoon, a populated area. There's a long interaction between these two before anything goes wrong. None of that, we'll see, looks like a robbery. So she says Mr. Oglivie says, this is how this is going to go. And then reaches in the vehicle and they're tussling. I want you to think about that and use your common sense as you hear that testimony. If somebody's armed with a firearm and he's about to commit a robbery, he's either going to say that and then tell you what to do, drop your firearms outside the vehicle, give us your money, give us your drug. He's going to give some additional instructions. Also, he has a gun. Think about that testimony as you're hearing it. He's armed with a gun. We're not disputing that he's armed with a gun. Is he going to reach in and wrestle with somebody over a gun? Or is he going to stand back to where they can't reach him, draw the gun first, point the gun at him first, be at a safe distance, and say, give us your stuff if he's committing robbery? It doesn't make sense. And that's one of the things that you'll consider when you're looking at the judge's instructions about being honest and straightforward. So she says she sees him reach in, she hears scuffling, and then she looks up. And they're fighting over a gun, and she assumes it's Miss Charlton's gun. Later she comes to believe that it was actually the defendant's gun, and he must have drawn first. So she hits the gas, she takes off, she hears a pop. I think Miss Cappleman actually told you in her opening that the pop happens before she takes off. That's not what she said. That's not what she'll say here, and if she does, I'll show her what she said previously. What she testified to previously, and I expect her to say here today, is that there was no pop until she slammed the gas down. In fact, she said, I felt bad because there was no discharge until I slammed the gas down and the car jerked forward violently. That's when the discharge of the firearm took place. So we haven't even gotten to the defense evidence yet. That's the state's evidence right there. Okay? They did some DNA testing. They tested the defendant's firearm. They swabbed all over that one. They swabbed the trigger guard, the magazine, the cartridges. They swabbed the barrel, the slide, all that stuff. They swabbed all over it. And Ms. Cappleman's going to try and suggest throughout the trial that that's the gun they were fighting over because the defendant produced his gun first. Well, guess what? Her DNA isn't on that gun. Now, look, you're going to hear testimony from the analyst about touch DNA. Touch DNA is when you touch something Sweat carries epithelial cells, skin cells. You can get DNA out of that. They can test it if you leave enough. It doesn't always leave DNA when somebody touches something, but the more contact there is, if you're fighting over it and hand fighting, the more likely it is that there's going to be touch DNA from you on that surface, right? An example, you'll see in this case where touch DNA isn't always left, even when we know somebody touched something, is the digital scale in this case. So the digital scale, the neighbor actually saw Mr. Oglivie and Mr. Knight and the girls, the digital scale, through the passenger side window. Ms. Charlton herself acknowledges that that's exactly what happened, that they handed it to Ms. Bryant, Ms. Bryant handed it to them, and she was supposedly going to weigh it in the vehicle, but wouldn't let them see what the weight was, right? So we know that that was handed in, we know that they both touched it, but when the Florida Department of Law Enforcement did DNA testing on that digital scale, they didn't find Ms. Bryant's DNA, and they didn't find Ms. Charlton's DNA. It's because they didn't rub their hands all over it. So there is DNA evidence, it's just not inculpatory. It doesn't make the defendant guilty or look more guilty in any way. In fact, one of the factors the court will tell you to consider again is, does the evidence agree with the other testimony and evidence? So when you hear Ms. Charlton testify that they were fighting, Ms. Bryant and the defendant were fighting over his gun, consider the fact that her DNA is not on his gun. And the reason for that, you'll understand when the defendant testifies, is that he didn't draw his firearm first. He only drew his firearm to protect himself. And so the defendant will testify in this case. Mr. Knight will testify in this case. Mr. Knight will tell you they've done this a bunch of times before, never had a problem. He's got a normal guy that he goes to. That guy was out of town or something, so he couldn't get it from him. So he just went on this app, found somebody. They didn't even have a plan ahead of time to hang out that day. They just ran into each other at the gas station, decided to go get some weed, as they usually did, and hang out. So they go over to this apartment complex. They're waiting there. They walk up, and he'll tell you that they were being weird from the beginning. I told you before, they wouldn't let him get in the vehicle, which is suspicious and strange. She made him go around to the other side, wouldn't put the windows down all the way, which is suspicious and strange. And they both had firearms out and displayed. That's not, I know you guys don't know, that's not normal for a drug deal. You don't display your firearm and make everybody tense from the very beginning. Nobody wants to do business to the extent that it's business like that. So he'll say, it was just kind of not going smoothly. She wouldn't weigh it in front of him. She wouldn't let him smell it. She wouldn't let him feel it, any of that. And so he is going back and forth at various times. He goes and gets a cup. At some point, they got the scale. Maybe they brought that initially. But he goes back and forth to his vehicle a couple times, which isn't very far away. And right before all of this occurs, he's gotten to the point where he's just done with it. And so he says, I'm done, and starts to walk off. And at that moment, Mr. Oglivie will tell you when he testifies himself, he reaches into the vehicle and he says, we fixing to go. Not, this is how this is fixing to go. We fixing to go. Because they were leaving. Mr. Knight's already walking off. The drug deal's not going smooth. He reaches in and he grabs his own scale, which belongs to him, doesn't touch Miss Bryant, doesn't do anything to Miss Bryant. He grabs his scale, and because she's not a drug dealer and shouldn't have been put in that circumstance, she freaks out. And she picks up the gun that she had in her lap, and she points it at his face, and simultaneously grabs his hand and starts yanking on it, trying to get the scale out of his hands. Now, do I think she had his intent going into this to rob him of his scale? No, obviously not. I don't even think she probably knew what he grabbed. But she took, with force, the scale away from him, made him drop it, and as she did that, he grabs her gun. He grabs the slide and the barrel on her gun, which was sitting on her lap, and that's when Miss Charlton sees them fighting over the gun. They're fighting over the gun because Miss Bryant picked it up and pointed it right in his face. And that's consistent with what Miss Charlton says. She saw him reach in, didn't see what he was reaching for, assumed he must have reached for her gun, and assumed they must have been fighting over her gun. Well, they were fighting over her gun. They were fighting over her gun because she drew it. Look, the defendant was armed. He's going to tell you that himself. They got his gun. He's got his DNA all over it. It's his gun. It is. That's the gun that killed the decedent in this case. There's no dispute about that. But her DNA is not on his gun because they never fought over his gun because he didn't draw his gun first. They were fighting over her gun because she drew it. Think about her testimony. Why would they fight over her gun when he's armed? Why would he need to do that? He wouldn't, right? And so they're fighting over her gun. And at that point, Ms. Bryant had caused him to drop his scale, and now he's got a hold of her gun, and she won't let go. And I expect the judge will instruct you at the end of the trial that if somebody's engaged in illegal activity, which Mr. Oglivie was here, he's doing a drug deal, he's carrying a concealed firearm without a permit, he's got a duty to retreat, unless it exposes him to additional risk of death or great bodily harm. She's got the gun right in his face, and the car's not moving yet. If he lets go, she can shoot him immediately. He's trying to push the gun away. She keeps trying to point it back at him. You're going to see that there was a prolonged struggle in this case, okay? Her shoe prints are all over the dashboard where she was kicking and struggling. You're going to see that he has handprints inside on the glass because they rolled up the window on his hands as they were struggling for the gun there, and he ultimately pulled his hands out and fractured the windows. But that's important too, because even though he was armed, and even though she drew the firearm first and they fought over the firearm, he didn't immediately draw his firearm and fire at her. Like, if he wanted to use defensive force in that moment, he could have done so. But he didn't. He pulled his firearm out and had it in his hand and stuck it in there to try and get her to stop trying to shoot him, but she wouldn't let go. She wouldn't put it down. The only reason the firearm went off at all, as Ms. Charlton herself said, was because she slammed the gas down and the car jerked forward. And when that happened, because she had rolled the window up, his hands were stuck inside. He yanked both his hands out, fracturing the window in two spots, what you can clearly see in the pictures, and the gun discharged. He thought at the time, he didn't even know until I told him that the gun that discharged was his gun and it was his bullet that killed her. He told Mr. Knight she shot after it happened. Mr. Knight will confirm that. He's not illiterate. He's a college graduate. He has a degree. He doesn't say she shot because he's saying she was shot, which is what he would have said if that were the case. What he said was she shot. He thought that she fired at him. But she didn't. His gun discharged when he yanked his hands out, as Ms. Charlton will have to acknowledge. You're going to hear the instructions on the law as I indicated at the end of the case. Defendant's charged with first-degree murder. State can prove that through premeditation, although I assume they're not going to try and do that because that didn't make any sense here. They can also prove it through felony murder, which the court will instruct you about at the end of the case. That's if somebody dies in the commission of a forcible felony, which robbery is, right? The problem with that is nobody can definitively say that it was a robbery. The state just doesn't have that evidence. Even Ms. Charlton says she didn't see what happened at the critical point. She just knows that they were fighting over the gun. She doesn't know why they were fighting over the gun. She thought it was a robbery. She assumed it was a robbery. She interpreted his statement as meaning it was a robbery. But it wasn't a robbery. And at the end of the day, this Cappleman, who's a great trial lawyer, is going to make all the arguments in the world about why you should believe that it was a robbery. The argument ain't evidence. And the question isn't, what do you believe happened? The question is, has the state proven the case beyond and to the exclusion of every reasonable doubt? The answer to that is just no. And as an added bonus for you, because this doesn't normally happen. Honestly, most situations like this are the state has the better facts, the defense has the benefit of the law because it's a very high standard, and it's tough. This one ain't like that. There's going to be very little dispute during the course of this trial. I'm not going to cross most of the state's witnesses because what most of them have to say is meaningless to the one issue that's in dispute in this case. There's not going to be many objections. This isn't going to be super adversarial. It's going to be an easy question for you to answer based on what the evidence is. Has the state's evidence in the form of Ms. Charlton's testimony excluded every reasonable doubt arising from the evidence conflict or lack of evidence? The answer is going to be quite obviously no at the end of the case. And although it's tragic that this happened, and I know everybody in here will want justice for her family, bottom line is the state's just not going to be able to prove their case. And for you, the good news about this case is, this isn't true for most jurors that get tasked with handling a first-degree murder case, you're also going to believe, based on the totality of the evidence, that the defendant is actually innocent, that he was actually justified as a matter of actual factual truth in this case. You'll see as we go through, there's not one single piece of circumstantial evidence that corroborates the state's theory of the case. Everything that you can possibly think of to suggest it was a robbery isn't there, and it actually cuts in the opposite direction. So I ask you to consider that. Keep in mind what the burden is. keep in mind what factors you should consider for weighing witnesses' credibility. And at the end of the case, I think you'll already be convinced without me even having to say anything. The state just failed to prove the case. No crime was committed here. It's the defendant's conduct is justified, and the state can't prove otherwise. Thank you.
Thank you, Mr. Prince. Ms. Cappleman, state's first witness.
State calls Officer Sean Wright.
Officer Wright. All right, sir, come on up and have a seat next to me. Thanks for your time. Come on up, have a seat. Once you sit down, I'll swear you and we'll take your testimony. Come on up, please be seated. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you shall give in this cause shall be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Please be seated. When you and the witness are ready, Ms. Cappleman, you may proceed.
Thank you, Your Honor. Sir, please introduce yourself and spell your name.
My name is Officer Sean Wright, SHAWNWRIGHT.
How are you employed?
I am a police officer with the city of Tallahassee.
How long have you been with TPD?
Been there since April 2014, and prior to that I was with Leon County Sheriff's Office for like 3 years.
All right, what were your duties back on January 26th of 2022?
I was assigned to the Uniform Patrol Northeast District.
As a part of your duties that day, did you respond to the Tallahassee Memorial Hospital?
Yes, ma'am, I did.
And what were you responding in reference to?
The call went out as a gunshot victim was being transported by a private citizen vehicle. It wasn't like an ambulance transport. They were being transported in a private vehicle to the Tallahassee Memorial Hospital. Typically when that happens, we start heading towards the hospital and looking, in the path that we thought it would be. We looked around for the vehicle. Dispatch had advised that they were at the hospital, but nobody could find where at the hospital they were, like which entrance or where they were. Finally, we got word that they were in front in the Magnolia entrance, like right there on Magnolia Drive. We're accustomed to going around to the emergency room entrance, and that's where most people were going. We're thinking they would go up the emergency room area.
Okay, but they did pull up to an entrance to the Tallahassee Memorial Hospital?
Yes, they did.
All right, and that's where you located the vehicle and the victim?
Yes.
And what time did you arrive and make contact with the vehicle and the victim?
It was right after the beginning of my shift at 4, so it was 4:40 something, 4:50.
4:45 sound right?
Yes.
And what did you see when you arrived there at that entrance to the hospital?
I saw the victim on the ground, face up, and medical. There were a couple of nurses and I believe a doctor there working on her. I think it was an internal medicine doctor that was working on her.
Okay, and did it appear that the victim had been removed from a vehicle and was just laying right there next to the vehicle?
Yes, very close.
And did you provide some medical supplies to assist the efforts of the medical personnel there?
Yeah, I was looking for an Asherman chest seal.
What is that?
So in the chest cavity, there's negative pressure that allows the lungs to expand and contract. And if there's a hole in the chest due to a puncture, whether it be a gunshot, knife, any kind of puncture wound, that pressure's disturbed, and you have to close off that hole in order to allow the lungs to inflate.
And were you able to provide such a seal for assistance?
Yes, I was. It was not effective, but I did eventually find one.
And during your assistance with the medical efforts there before she was moved into the hospital, did you observe a gunshot wound to the victim?
Yes.
Tell the jury where that was.
It was, I believe it was the lower right area, right under where the breast meets the chest wall.
And during the time that you interacted with the victim, was she conscious?
At no point was she conscious.
And was CPR one of the efforts that was being made to save her life?
Yes. I don't remember if it was a nurse or one of the patient care techs that was on scene doing CPR, but they already had an ambu bag and had started CPR.
And did you have on a body-worn camera that day?
I did.
Have you had an opportunity to review your body-worn camera, which I've marked as states 45?
Yes.
Right. And does it fairly and accurately capture what we just described?
Yes.
Judge, at this time, I'd ask to move into evidence states 45.
States 45 is entered in evidence.
May I publish?
You may proceed. Is there sound with this, Ms. Cappleman?
Yes.
Cool. He's gonna cover that. Where's the chest wound at? Okay, I got a chest seal. We're gonna try to get on. Where's the chest wound? That's from our chest seal. I need somebody. I need to get another unit up to the front of the hospital with this car for evidence. We got the gun inside. Dispatch, we have a couple of these on scene that are getting her up to the ER on the stretcher here. Hey. Pearson, stand 10 foot with this, and then I'm going to get around to the ER and start with her so I can stand low.
Officer, did you assign somebody else to stay with the silver Lexus that we see in that video?
I did.
And where did you go?
I went to the emergency room, and then ultimately I ended up following her into the surgery.
And were other officers responsible for processing the Lexus and collecting whatever items of evidence were in there?
Yes.
I heard you say on the video that the gun was in there.
Yes.
Is that something that was told to you?
I honestly don't remember. I can't remember if I saw it or if it was told to me.
And what happened in the OR?
Dr. Pennington performed life-saving procedures. He opened up her chest cavity, and at some point, I want to say vascular surgery came in and said that the damage to to the vasculature going to her lungs. I don't remember if it was the pulmonary artery or pulmonary vein, but the vasculature was too destroyed to be able to be repaired.
So her injury was not survivable.
Correct.
And was she pronounced deceased there in the operating room?
Yes.
Were you able to identify the victim in this case?
Yes.
Who was that?
I forget her name. MaKayla.
MaKayla Bryant?
Yes.
And how old was Ms. Bryant when she was killed?
I think 22.
Judge, at this time I asked to introduce State's Exhibit 1, the exhibit I published during opening statement.
States 1 is entered in evidence.
This is Ms. Bryant.
Yes, it is.
Further questions?
Any questions for the witness?
No, Your Honor.
Thank you, sir, for your time. You may step down. Any other witnesses or other evidence for the prosecution?
State calls Dr. Flanagan.
All right. Thank you. Dr. Flanagan, come on up. I'll swear you in and we'll take your testimony. Come on up, have a seat. Or you just raise your right hand, that'd be fine. Do you solemnly swear or affirm the testimony you shall give in this cause shall be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Ms. Cappleman, when you and the witness are ready.
Please introduce yourself and spell your name.
Lisa Flanagan, that's Flanagan.
How are you employed?
I am a medical examiner for this district of Florida.
What does a medical examiner do?
As a profession, I investigate deaths, and I'm trained as a forensic pathologist.
What is a forensic pathologist?
A forensic pathologist I'm a medical doctor. I specialized in pathology, and then I further subspecialized in forensic pathology, where my responsibilities include performing death investigations and autopsies.
And what is your training and education that qualifies you to do this type of work?
Well, I received my undergraduate degree from FSU. I then attended the University of Florida College of Medicine, and I received my MD degree in 1990. And after that, I completed a 5-year residency program in anatomic pathology, clinical pathology, and a 1-year fellowship position in forensic pathology. And I did that at the University of North Carolina in Chapel Hill. And
I'm sorry to interrupt you. If you'll mute our audio, we can probably rid ourselves of something.
My apologies.
Okay, sorry, go ahead.
And after residency training, I got a job down in South Florida as a medical examiner, and I've worked in Florida since 1995 as a medical examiner.
You said, you mentioned autopsies. Are autopsies part of the ordinary course of business for you and your job?
Yes, they are.
How many autopsies have you performed in your career?
At this point, probably over 5,000.
Have you testified as an expert in forensic pathology before?
Yes, I have.
Is that here in Leon County?
Yes, Leon County and other jurisdictions.
How many times have you testified as such?
Over 100 times.
Judge, at this time, I would tender Dr. Flanagan as an expert in the area of forensic pathology.
Objection or voir dire?
Stipulate, Your Honor.
You may proceed.
Doctor, did you conduct an autopsy of a MaKayla Bryant?
Yes, I did.
When and where was that autopsy conducted?
It was done at the medical examiner's office on January 27th, 2022.
Do you have any notes to advise the jury of Ms. Bryant's height and weight?
Yes, as part of the autopsy, we will measure the body. I have it 65.5 inches and 142 pounds.
photos as part of the autopsy?
Yes, I do.
I'm going to approach and show you what I marked as states 2 through 14. Let me take a look at those. And if you'll turn them the right way, if I've got them wrong, while you're at it, that'd be great.
Okay.
Do you recognize these as fair and accurate photos of the autopsy you conducted of MaKayla Bryant?
Yes, I do.
At this time, I'd ask to move into evidence states 2 through 14.
States 2 through 14 entered in evidence. You may proceed.
Okay, if you could just kind of walk us through the process of conducting an autopsy. How do you begin?
The autopsy begins with looking at the outside of the body. Photographs are taken throughout. So photographs are taken before we do anything to the body. And then the body's cleaned, everything's documented. I take notes and photographs. If someone's been shot, then we'll take an x-ray so that we can see if the projectile's still in the body and where it is. And so then the body's cleaned, all of the injuries are documented, and then ultimately the body's opened up and all the internal organs are examined for injuries and for any underlying diseases that someone may have.
Did you take x-rays in this case?
Yes, I did.
Publishing states 2. What does this x-ray show? I do have a pointer for you. I know the glare's not great on this. Last one.
Okay, this is a chest x-ray that was taken, and what you can see here is the projectile that is still in the body. These objects are left over from surgeons going in there, and when they pack the body with cloth, these are attached to it so that they can be seen on x-ray.
Publishing states 3. What does this exhibit show?
This is a lateral view that we take so that we can see the projectile. In this particular photograph, it's showing where they had placed the towels, but the projectile was here in the back area.
Publishing states exhibit 4. What's the purpose of this photograph?
This is what we call the identification photograph, and it's just a straight-on view of the individual's face with the case number.
Publishing states 5. Is there an injury depicted in this photo?
Yes, this is one of the initial photographs, and she had been taken to the OR, and so you can see where they have opened the body and sutured back these incisions along her abdomen. Her head is here at the left of the photograph, and here at the bottom is her right arm. So what this is showing here on her right breast is the entry gunshot wound right there.
States exhibit 6. What is this?
This is a close-up of that view, so it's on the lateral side of her right breast.
States exhibit 7. Is this the correct way?
Yes,
Show it?
yes.
What does this depict?
This is a photograph that's taken after the chest plate has been taken off, so the skin's reflected, and then the anterior ribs and sternum are taken off. Her head, again, is here at the left of the photograph. The heart is under here in this sac, and what is shown here is this right chest cavity. Her right lung is here, but this dark fluid, all of this is blood that's pooled in that right chest cavity around the lung.
Should that blood be there?
No.
So that was caused by an injury?
Yes.
Bullet trajectory?
Yes, she had, as I said, made it to the operating room, so they had opened her up and they had given her several units of blood, but she was bleeding into that chest. This is a closer view of that after some of the blood has been removed. So this is the lung, which you can see is hemorrhagic because there's an injury of the lung itself. And here on the top of the photo, this is what the lung tissue, healthy lung tissue looks like.
What does hemorrhagic mean?
Just bleeding into the tissues of the lung.
States Exhibit 9. What does this one show? Do I look at?
No, it's fine. This is again with her lying in that same position, so her head would be here to the left. What this is showing is the top of her liver, and what's being held back is her diaphragm. So on her right chest, the lung is in the chest cavity, then there's the diaphragm. That's a thin muscle, and right below that is the liver. So right in this right upper abdominal quadrant, the projectile did pass through the top of the liver, so this is showing how it grazed the liver.
States Exhibit 10. What does this exhibit show?
This is showing, this is the heart here that's on the left, and it's been raised up, so it would be down, lying down. It's flipped back towards her head. This empty space is the right chest cavity where the lung has been removed. What's being shown right here is an injury of the pulmonary vein, which is a blood vessel that goes from the lung to the heart, and that was injured.
And is that a main vein that would that be survivable if that injury had sustained by itself?
It's a serious injury. I mean, it's right there by the heart, so it's under a lot of pressure, so she would be bleeding from there.
Exhibit 11. Tell us about this exhibit, please.
This is a photograph that is, again, the same view, so her head would be here to the left, just showing the overall path of the projectile. What's been placed here is a metal probe that was placed there by me just to demonstrate and show the wound track. So the lung has been taken out, the heart has been taken out. What you can see under the number here is the liver, and this is showing how the projectile came in the lateral right breast, went through the hemidiaphragm here, injured the liver, went through the lung, injured the pulmonary vein in this area, and then penetrated into the thoracic spinal column.
States 12. What does 12 show?
This is where part of the spinal column has been reflected. So you have your spine, and in that is the spinal cord. And so the spinal column is the bony structure that's protecting the cord. So the projectile passed through that. So part of the bone was taken away to examine the actual spinal cord itself. And what you can see here is where it's been transected. So the bullet actually passed through the spinal cord and transected it.
And what impact did that particular injury have on Ms. Bryant?
She would have been paralyzed below that level of injury.
Was the
Yes, it was.
Publishing States 13. Could you tell us about this, please?
In order to recover the projectile, I will have to incise the skin to remove it, which is what this injury is here, is what I did to the body in order to get to the projectile. And the projectile was in the mid-back area, just to the left of the spine.
States Exhibit 14 is just a photo of the projectile after it was removed from her body.
Yes, once I take the projectile out, then I will photograph it, and then it's turned over to law enforcement.
Judge, at this time, I would also seek to introduce by stipulation the projectile itself, which I marked as States 48.
States 48 is entered in evidence.
What was the cause of death in this case?
It was a gunshot wound of the chest.
And do you know what caliber of weapon did this damage?
No, I do not.
What was the manner of death in this case?
A homicide.
Further questions?
Cross-examination?
Yes, Your Honor, just one quick question, just to
Whatever.
clarify. When you classify a death as a homicide, you're not offering any opinion on the lawfulness of the death. You're just saying homicide means another person killed that person, correct?
Yes, that's correct. There's only 4 or 5 choices that we have for the death certificate. It's natural, suicide, homicide, accident, or undetermined.
Thank you. No further questions.
Anything else for the witness?
No, Your Honor.
Thank you, ma'am, for your time. You may step down. It's 3 o'clock. Ms. Cappleman, should we take a brief recess? You want to press on?
We can take a break.
All right, so members of the jury, we're going to take 15 minutes at this time. Remember, don't discuss the case amongst yourselves or with anyone else during this brief recess for your comfort as well as ours. 15 minutes. 3:15. Notepads and chairs. Thank you, Deputy. Jury's out. Doors closed. Ms. Cappleman, any matters we need to attend to at this moment? Mr. Prince?
All right.
We're in recess until 3:15. Thank you, folks. All right, so we're back on the record. State of Florida versus Khalil Oglivie, 2022 CF 288. Mr. Oglivie is present. Ms. Cappleman, anything before we bring the jury in? Mr. Prince?
No, Your Honor.
Whenever you're ready, Deputy. You can stand up when the jury comes in. Yes, ma'am. Just when, well, that's fine. It'll take them a minute to line up, so if you want to sit, you can. Just stand up when they walk in the room. Jury in the court. Thank you, folks. Come on in, find your seats. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Thank you, folks. All jurors are present. Please be seated. Be seated, everyone. State's next witness.
State calls Precious Charlton.
Ma'am, would you please turn to me and raise your right hand? Do you solemnly swear or affirm the testimony you shall give in this cause shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
When you and the witness are ready, Ms. Cappleman, you may proceed.
Please hold that microphone, say your name and spell your name.
Precious Charlton, Preciouscharlton.
Ms. Charlton, how did you know MaKayla Bryant?
We went to school together.
And were you in a relationship?
Yes, ma'am.
Girlfriends?
Yes, ma'am.
And how long had you been dating at the time of Ms. Bryant's death?
Like 3.5, 4 years.
Did you live together?
Yes, ma'am.
As previously introduced, State's Exhibit 1, which I'll now publish, is that Ms. Bryant.
Yes, ma'am.
And I see she's wearing a cheerleader uniform. Was she a cheerleader?
Yes, ma'am. She was a captain.
Was she a cheerleader at the time of her death?
No, ma'am. Just because she had graduated, so she was helping out with the team.
From where did she graduate?
Florida A&M.
Okay, and you said she was helping out. Who was she helping out with?
She was helping a coach, being a grad student, helping with the girls.
Okay, so at the time of her death, she was a grad student at FAMU
Yes, ma'am.
and a cheerleading coach.
Yes, ma'am.
What was she studying?
She did criminal justice in undergrad and was studying like childhood psychology for the masses.
And I told you to speak into the microphone, but I have to back up just about an inch or two from it. All right, so child psychology, is that what you said?
Childhood psychology, yes, ma'am.
Okay, and were you also a student at the time that this occurred?
Yes, ma'am.
And what were you studying?
I was still in undergrad studying general health sciences.
How old were you when Ms. Bryant died?
23.
I want to take you back to January 26th of 2022. What were you doing that day?
Just
Did you have class that day?
not yet.
What about Ms. Bryant? Did she have class that morning?
She just woke up and went to work.
Where did she work? As a cheerleading coach or something else?
Finish line and
Let me get
she
you
worked at
back.
finish line in the
Let
mall.
me get you, roll the chair back just a little bit.
Okay.
There you go.
You don't have to do that far, but I know it's difficult. Just when you write up on it, we get a little bit of a muffled sound. All right, so she was working at Finish Line.
Yes, ma'am.
And did you at some point that day set up a drug deal?
Yes, ma'am.
And with whom did you set up the drug deal?
I didn't really know them.
You didn't know the person?
No, ma'am.
And did you do it through an application on the phone?
Yes, ma'am.
Could you explain for the jury how that works?
When you first come to school, you might don't always go to class, or you might don't talk to your classmates every day, but they have an app called Group Me just in case you want to group me, and just if you want to see, maybe if you want somebody to sign you in for attendance, or if you want somebody to tell you the homework, or tell you what chapter you got to read for school. It was just a school app, essentially.
So you're able to text and send messages through the Group Me?
Yes, ma'am.
All right, and did you post some kind of advertisement on there? How do people know to contact you for the Group Me to buy drugs?
It just would be specific groups. Sometimes people would try to get their hair did. Sometimes people would want to buy weed on there. So it was a specific group.
All right, so in the specific group, you were able to say, hey, I've got weed for sale.
Essentially.
Okay. And when the person would reach out to you through the group me, would you be able to see their phone number?
If they texted you,
And in this case, did the person text you from a phone number?
yes, ma'am.
Was it a Destin, Florida phone number?
Yes, ma'am.
Did you know that phone number? Have you recognized it as someone you communicated with before?
Not previously.
Was this something you were doing as a regular practice, selling weed through this group me, or was this like the first time this had ever occurred?
I had done it before.
And in this case, what were you selling this individual that contacted you from a Destin number?
I was supposed to sell him a quarter pound for $650.
And it's a quarter pound of marijuana?
Yes, ma'am.
Okay, is that the normal amount that you were selling, or is that more than what you usually sell?
Maybe a couple times prior to I had done it, but I was still fairly new to that large of an amount, but I had done it a few times.
So how much would you typically, the amount won't be much to us, but how much money would you typically do a sale for?
I mean, if you had 20, 30, 50, just smaller amounts, 100
Okay, so somewhere between $20 and $100, which are typical transactions.
on a regular.
Okay, and this transaction was supposed to be $650.
Yes, ma'am.
All right, and had you advertised, I have a quarter pound, or had the person reached out to you and indicated that's what they wanted?
I believe they indicated that's what they wanted. I think I had stopped at like a smaller increment.
All right, I'm going to approach and show you what I've marked as states 15, 16, and 17. You recognize these exhibits?
Yes, ma'am.
Are these fair and accurate screenshots of the communications you had with that Destin phone number on the date in question?
Yes, ma'am.
Judge, at this time, I'd ask to move 15 through 17 into evidence.
15, 16, and 17 are entered in evidence.
And publish.
You may proceed.
Publishing 15. So here we see this phone number and 3 missed calls. Did you have missed calls from that person on the day in question?
Yes, ma'am.
And did you talk to the person at all prior to the incident we're hearing about today?
No, ma'am.
Okay, so you only communicated via the texting app?
Yes, ma'am.
Publishing states exhibit 16. All right, it says, "What's up? Trying to grab some za." Is that you, or is that the person with the Destin phone number?
The green is me and the gray is them.
All right, so what's za?
It just means like a higher grade of marijuana.
All right, and then you sent a picture of, is this cannabis here?
Yes, ma'am.
And then what happens next? They say this, what do you take this to mean? Can you translate it for us, or if you don't?
I mean, it just pertains to the strain itself, like just because it say jet fuel, sometimes like the phone will suggest a jet because you typed in jet fuel.
Right, but in general, they're saying a QT, what is that?
Oh, that's the quarter pound it was referring to. Okay, so at that point, I thought he meant a quarter, as in 7 grams. So I respond and say $60. So I'm initially texting back thinking this is for $60 when I first text back.
Okay. And then he says this, QT ma, what does that mean?
Essentially clarifying, I don't mean 7 grams, I mean a quarter of a pound.
Okay, and so that's when you advise him to spend $650?
Yes, ma'am.
Right, and why do you say don't call me mom?
I never posted nothing that would let anybody know whether I was a male or female. So I just kind of felt,
How would this person know that you were a female?
in hindsight, I guess they wouldn't.
What was your profile name on the application that was used, the group name?
JP.
JP. All right, so this person is referring to you as mom. You say, don't call me that. Is it your preference that the people that you're making these deals with or setting up these deals with not know that you're a female?
Generally.
Do you think in general it could make you more vulnerable if you're a female selling drugs?
Of course.
Published States Exhibit 17.
you want us to turn the lights off, maybe?
Alright, so here the person says, my bad, I'm in Tally on the south, and wants to try to link up. And you say, Addie, what does that mean? Okay?
The address,
And who sends this address? 1242. He does?
yes, ma'am.
Okay, and then 9 minutes, what does that mean?
Essentially letting them know my ETA from that location.
That you're going to arrive at Stuckeyard in 9 minutes?
Yes, ma'am.
And did you arrive in roughly 9 minutes?
In that ballpark.
Okay, and you said outside, and he says coming out. Did you see anyone emerge from the building?
No, nobody came from out of the building.
Where did somebody come from?
They just emerged from the bottom of the hill, just with a lot of other cars.
And what's at the bottom of the hill? There's a bunch of cars down there?
Yes, ma'am.
All right, is there this stuff that you have, is it an apartment complex? Is that where you went?
Yes, ma'am.
Can you describe the parking lot? You pull in, and which way can you go?
When you first come in, it's essentially like you're driving down the hill. There's two rectangular buildings on the left and the right. But once you get down to the end of the hill, the parking lot is T-shaped. So you could either park this way or this way, and then in the middle. So I observed them walking from further below, because again, everything's on the hill, so I'm higher on the hill at this point when I park.
All right, and do you park sort of in the middle where the buildings are?
Yes, ma'am.
Okay, and so the people that approach you come from the T, down the hill where the T is?
Yes, ma'am.
Right? Okay, so they didn't park right next to you in the middle part.
Mm-mm.
All right, so when they come up the hill from the T, let me ask you, so you talked about there's an entrance where you can come in. Is there any way to get out from the T part?
No, it's a dead end down there.
All right, so one way in, one way out.
Yes, ma'am.
Okay. And did Ms. Bryant go with you to do the drug deal that day?
Yes, ma'am.
Is that something that was typical for her to go along with you?
We've done it previously.
And when you said the men emerged from the back of the T part, had you ever seen either of them before? Did you recognize them?
No, ma'am.
All right, this 1242 Stuckey Ave, that's where you went?
Yes, ma'am.
And is that in Leon County?
Yes, ma'am.
What type of car were you in that day?
We have been driving her car. It was a truck.
Is it a Lexus?
Yes, ma'am.
Show me States Exhibit 20. Is this the vehicle you were in that day?
Yes, ma'am.
Move into evidence States 20.
States 20 is entered in evidence. You may.
Who was driving?
I was.
And was it normal for you to drive her car?
Usually.
You would frequently drive her car?
I mean, it didn't matter if we was in her car or my car. She just liked me to drive.
You would usually drive.
Hmm.
And was she seated in the front seat?
Yes, ma'am.
Were the two of you armed with a firearm?
Yes, ma'am.
And what type of firearm did you have?
A TARS G2C.
And what about the other firearm that Ms. Bryant had?
Maybe a 9mm XD.
An XD?
Yes, ma'am.
Okay, and are those both handguns?
Yes, ma'am.
Those guns?
Mm.
And who purchased the guns, or who owned the guns?
MK purchased both of them legally.
Okay. And when you would go to do drug deals, would you always take guns with you?
Nah, not in particular.
Okay. Had you ever done it before this incident?
Yeah, I had if it's something bigger, just extra precaution.
Okay, so it had to do with the amount of drugs and money involved, your decision to bring the guns this time?
Yes, ma'am.
And what were the guns designed to do? Like, why bring them?
I feel like sometimes when you see females, They might kind of associate you being weaker, but a weapon kind of put everybody on the same playing field. So maybe in a sense, like, you got this, and okay, now we on the same playing field. Maybe I don't see you as being so weak or feminine or anything like that.
So is it designed to protect you from the drug buyers?
I mean, if it had to get there, but it wasn't even intended to be that. It was more so just adding some bravado, just adding a little bit of just letting you know, like, it's lingering there, just kind of keeping that there, essentially.
The idea was that maybe anybody would mess with you if they saw the camera.
Yes, ma'am.
I'm going to show you what I've marked as states 49 and 53. Showing you states 53. Is this one of the firearms that you all took with you that day?
Yes, ma'am.
And states 49. Is this the other firearm that you took with you?
Yes, ma'am.
Judge, I'd ask to move into evidence these two exhibits.
States 49 and 53 are entered in evidence. Did you ever move 48, Ms. Cappleman, the projectile?
Yes, sir, I believe I did.
48 is entered in evidence as well.
Let's start with the XD. May I publish, Your Honor?
You may.
Can you tell the jury for sure which one of you had which gun?
MaKayla had an XD.
I'm sorry, what?
So MaKayla had an XD. I had G2C, the TARS.
So this gun is the one that MaKayla had.
Yes, ma'am.
Publishing states 53. There's the availability.
I think she just blamed you for something.
All right. Once you arrived, did you display these firearms, or where in the car were the firearms?
It was never really like holding them, just essentially like having them in a lap. Because again, like I said, like they had to see them in order for them to serve their purpose. So just like envision.
Okay, so you weren't holding them, but they were resting on your lap in a way that could be seen by anyone that approached.
Yes, ma'am.
How much approximately do you weigh, or did you weigh at that time?
Like 130, 132,
How tall are you?
5'4.5".
How did you have the drugs stored when you arrived at the location?
It was in a clear gallon bag, and the clear gallon bag was inside of a white finish line bag.
And what I've marked as states 44. Is that what it was?
Yes, ma'am.
Moving to states 44.
44 is entered in evidence.
May I publish?
You may.
And is this a quarter pound?
Yes, ma'am.
All right, so this bag would have been inside the white bag at the time.
Yes, ma'am.
All right. Where was the finish line bag when you were sitting in the car waiting for the fire to arrive?
It had either been in my lap or underneath my seat. It was close by.
Was what we saw in State's Exhibit 44 all of the drugs that you had in the car?
No, ma'am.
What other drugs were in the car?
I had maybe another pound or two in the trunk.
Another pound or two
Yes, ma'am.
of cannabis?
Yes, ma'am.
And what, if you know, is the street value of the total amount of drugs you had in the car, including what you were going to sell to these guys?
A couple thousand.
Were you charged in reference to the possession of the cannabis?
Yes, ma'am.
Is that case open or closed?
I'm doing my sentence for it, but it's closed.
What is your sentence?
2 years on probation. I had to take a felony. I had to do drug court. And I also came here today to speak.
When you take a felony, does that mean you're a felon now? You're adjudicated?
Yes, ma'am.
Have you been promised anything in exchange for your testimony here today?
No, ma'am. I just want to do the right thing.
You mentioned that it's part of your plea deal other than tell the truth. Have you asked to say anything by anyone here in court?
No, ma'am.
When you get to the target location, did you pull in straight or back into the parking spot?
I bagged in. I didn't know how, I didn't want to go all the way down. So, but once I saw it was a good space with 3 or 4 empty spaces, I just went ahead and backed in that space, like in the middle.
And when you say all the way down, you're talking about down to that T part?
Yeah, I didn't want to go down there.
Let me show you states 18 and 19. Recognize these? Okay, are these fair and accurate photos of the parking lot in question?
Yes, ma'am.
Judge, at this time, asked to approve the evidence 18 and 19.
States 18 and 19 entered in evidence. You may.
Publishing states 18. Does this photo depict the area where you parked the Lexus that day?
Yes, ma'am.
Where on here did you park the Lexus?
On the left side, next to that silver car.
Okay, closest to the camera?
Um,
There's a pointer on your so if you push this button, you get a red
Yeah,
dot.
right there.
Show us.
Push that one.
Yep.
right there.
Okay, so right there in that empty spot in front of the silver car?
Yeah, right there.
Publishing states 19. Is this the part of the parking lot you referred to as the T that dead ends the back?
Yes, ma'am.
And is this the general vicinity from which the men emerged to come up to your car?
Yes, ma'am.
When they came up to the car, which side of the car did they come up to?
They approached the passenger side.
They didn't come up to your window first?
Now, like how I had bagged in, I was to the left, so like the entrance was over there. So since they was further down, they was coming from the right. So the way I had bagged in, they was coming up from the right. And just before I even have a chance to, like observe anything, she kind of just like start rolling her window down, kind of, oh, here they go, like initiating kind of contact a little bit.
So Ms. Bryant started rolling her window down to engage with the guy.
Yes, ma'am.
Okay, and so at any point did they come around to your window?
No, ma'am.
Was your window up or down?
Mine had been up just with a car being directly to my left, like on this side, And then with it being 3 or 4 empty parking spots on the other side, it was just more room. I guess everybody just maintained on that side of the car the whole time.
There was more room for the men to stand on her side because there's no car over there?
Yes, ma'am. It was empty parking spaces.
And is your window up or down?
It's up the whole time.
And her window was up when they got there, but then she rolled it down all the way or something else?
Maybe like 30%, enough to be able to observe what's going on, but it's not all the way down.
Describe who approached. We know it's 2 men. Can you tell us anything more about them?
It was a dark-skinned dude with a pooh shiesty mask, kind of covering. Maybe like a ski mask would be the general term. Just a mask that became more popular during COVID. So you would kind of see more kids covering maybe this side or all of this at the time.
All right, so the person had on, there's 2 guys, right?
Yes, ma'am.
One of them has on this mask that looks similar to the style of a ski mask.
Yes, ma'am.
And what about the other one? Is he masked as well?
Nah, he just had like a beanie on.
Okay, are they both black males?
One dark skin, one like brown skin.
Okay. And what about their approximate ages?
I knew one had a baby face for sure. The brown skin one could be maybe 19, 20. The dark skin one looked older in the face, so I couldn't really put an age on it.
Okay. You said that the type of mask that he was wearing was popular or made more popular during COVID. Were you alarmed by the fact that the guy was wearing a mask?
Nah, I mean, MK had got me some for Christmas. Like, that's how popular they was. Like, they call them shiesties. Everybody just wear them. It's kind of, you can hide your face, but you protect yourself from germs, you know, at the same time.
And is this something that goes all the way over your head as well?
Yeah, you can kind of like dictate though how much of your mouth is covered, but it definitely covers the whole top of your head.
Did you observe either men upon their approach of the vehicle to be armed or carrying a firearm?
I ain't had no indication.
Okay, what happens when they get up to the window there?
We kind of just like confirm a little bit, like, hey, what's up, like, that's you. Just because, again, we don't know who we are for real until we get there. So it's kind of like, oh, that's you. Yeah, like, I'm trying to get that in a sense, like, just like, okay, we're who each other is looking for, essentially. We just kind of confirm that off real.
All right, and did you do that with the one in the mask or the other one?
Yeah, the dark-skinned dude in the mask, he stayed maybe 2 or 3 inches away from, like, the car. So the brown-skinned one, he was maybe 4 or 5 feet away. So being where I was sitting, looking out the passenger window, I had a better vantage point of the brown-skinned one because I'm further away than anybody else is. So I'm just basically able to see everybody's vantage point. I'm able to see her, him, and the other guy, like, in the corner over there.
You said they came from down the back of the T, but I don't think I asked if you were able to see what type of car they arrived in, what type of car they got out.
I didn't see.
Did you or MaKayla ever get out of the car during this transaction?
No, ma'am.
Which one of the 2 men seemed to be in charge, if there was such a thing?
The dark-skinned male definitely,
That's one in the mask.
he spoke. The other one didn't even speak.
At some point during this, did somebody one of the men hand you or MaKayla a small black box?
Prior to the black box coming up, it was basically like, hey, you got the stuff, and I say, hey, do you have the money, essentially. So he's fidgeting, showing $100 bill. So since he's showing a little money, I'm like, okay, I'll show a little bit of the bag. So I showed a little bit of the bag, and he's like, oh, I don't know if that looks like that amount. I'm gonna get my friend got this cup, and I got this scale. So if my friend, just some big story, if his friend is able to weigh up a sip in the cup or an ounce in the cup, he would be able to know that from this one that the rest is 3, essentially like eyeballing it if he could weigh one amount of it. So that's how the scale got introduced. Like, I'm not sure if that's the amount, so I'm going to introduce the scale into the conversation, basically.
Did they introduce the scale into your vehicle at some point?
Yes.
And did the cup ever come into your vehicle?
The cup was never produced that the friend had. I never seen the cup.
But the idea was somehow they were going to try to weigh this product in the cup using the scale
Mm-hmm.
to determine if it was, in fact, the amount you claimed it to be.
I guess they wanted to see if it was at least 25% of the amount I was supposed to have, so they could infer based off this much that that was 3 times that, essentially, I guess.
Is that something you had ever encountered in your prior drug selling experience where they wanted you measuring with the cup?
I mean, I think on both ends, like, you know, on the other end, somebody could feel like, hey, I'm not going to get my money's worth, or I don't know you, you could give me the short end of the stick. So I think it's, you know, sometimes both people can come in with like hesitancy just because of the situation.
Were you open to doing the measuring?
I was like contemplating it, and I like just check my phone just to kind of see how much time I had been sitting there, just to kind of like.
Did it feel like this was going on for a long time or too long?
A little bit.
And was there ever a dispute or a disagreement?
Nah, it was never that.
Did anyone say any cross words about you're trying to rip me off, or I don't think it's the right amount, or anything like that?
No, honestly, once he said, "Oh, my friend can get the cup," and I looked down, he hadn't said anything, and then he just said, "Oh, this what I'm finna do. This what's finna happen." And I just hear, like, when we first was talking, at first, like, you know when a male wants you to hear them, at first it was like we talking regular, like friends, or just, you're not even friends, just we talking regular, like, as we just talking regular. And then what really just stuck me back to the conversation was like, just put a lot of bass in his voice. He just came back with "Oh, this what I'm finna do," or "This what's finna happen." Very strong, like, so that just pulled my attention back to over there.
And the man that said that, was that the one in the mask, darker skinned guy, or the other guy?
Yes, ma'am. The dark skin one.
At any point prior to that statement, had either of them wanted to get in the car with you?
Nobody made any type gesture to get in.
Was it your typical practice to have men get in and out of the car that you're selling weed to?
Nah, they never would have gotten a vehicle.
But these guys didn't ask you to do
Not at all.
that. So the weighing, was that going to happen inside the vehicle, like you were supposed to put it in the cup to show them?
We had actually, like, we had parked around the corner before we even got there. That's why when I said the 9 minutes, we were somewhere else, already making sure it was going to be the exact amount.
Right, but when you, assuming you had gone through with the cup thing to demonstrate for them it was the right amount, what was your understanding of where that weighing was going to take place? Were you going to get out of the car and do it? Were you going to give them the weed to take something?
Nah, they would have handed me the scale and the cup into the car, because again, we wasn't getting out the car, and the window was only open just so much, so it was only so much access into the car anyways.
Was there ever any exchange of money between the parties in this drug?
Nah, it was just like I said, it's just something about how he just kept grabbing this $100 bill, just only one bill. I only seen $100 bill the whole time, just kind of playing with the $100 bill, like getting it out, pushing it back in, getting it out. But I'm like, okay, well, you have at least 100. I'm not seeing that. That's how much I seen. It was $100.
And were you suspicious that that might be, they might not have the money?
Kind of, yeah, more so aggravated. Not even like scared or suspicious, just more so like aggravated. Like, oh man, like, you know, here you go. You know, here we're finna waste some time. Essentially, like just that.
Were you getting scared? Were you feeling in fear?
Not at that time. Not prior to him raising his voice.
What about when he made the statement about this, how it's fixing to go?
feel like once I looked over and seen what was happening, I kind of felt like frozen almost, like just stuck exactly where I was at, right there.
So you looked over and saw what was happening. What did you see?
They was like, he hadn't put a gun in the car, so like it went from talking about handing the scale to putting a gun in the car, and I'm just looking over and I just see her like just going like this, trying to pull it back, like they just both wrestling, like going like this, and I'm just staring for like 4-5 seconds. I'm just like, dang, like I don't know what to do, and it's just like pop. I'm like, dang, let me speed up. So I sped up. As soon as I heard it was just a big old pop, they just was fighting over the gun like this. They both just fighting, and I could just see her just putting her body into it like this. And he said he probably just surprised she actually strong, so just like this, they going, and it's just boom, you just hear it. So I'm like, let me leave now that something really happened. That's what really just brought me back to reality, and I just pulled off.
Right, you said he had his arm inside the car. Was it one arm or both?
It looked like both of them, like essentially, again, she's stronger than most, like she's a collegiate athlete, like actually have been cheering for a long time, so like she was really she could really make a grown man work, like you really like putting your whole body into it almost. So it's they're really going back and forth, like I could tell this is a real, like this is a fight for your life for real. They really just going like this, and I'm just stuck, like I don't know what's gonna happen in the midst of this fight. I don't know. It's nothing I could do from this driver's seat, so I'm like, I don't know what I'm finna do. And that's when it just smacked me to reality, like it just went off.
Was there a moment where you thought that the gun in question that they were fighting over was the gun that MaKayla had on her lap?
Basically, I didn't know until I got there, got her out the hospital, and actually seen his gun, because I looked down at my phone. Again, he kept saying some like, oh, this. So I'm like, let me just check my phone. I'm just looking at, maybe finna change the song, or maybe just looking at the time. Just I don't know how to explain it. I was just peeved with the conversation, or maybe I was mentally like, I'm not all the way there, so I just looked at my phone. And I look at my phone, and that's when I heard him say it. So maybe in the midst of him saying, oh, this how this finna go, he just up it and pull it in there. So again, I'm thinking maybe he had reached down and got hers, or that's what happened. It wasn't until I get to the hospital, I'm getting her out the car, I'm seeing a gun I've never seen before with stickers and all type of stuff. So I'm like, I know that's like not hers.
When they were wrestling over the gun, were you able to see the gun enough to tell which one it was at that point?
Nah, because like you got to think like the way the vantage point is, like in a car you directly side by side with somebody. So if I'm right here, she's right here, so I'm looking like this as this is happening. And again, in the fight, they're just like this. Everything's on this side of the body. So if you're directly right here and you just see people over, you get what I'm saying? I can't really see what the object is, more so just the fact that I see both y'all going at it. Again, all this is from just the angle of me looking over, and it's very close, happening like that.
And you're not able to tell where MaKayla's gun is at that point, like if you're not seeing her gun on her lap anymore.
No.
And is she struggling in such a way that the gun would have still been on her lap, or was she like whole body moving around such that the gun would have been knocked off her lap?
I think anything like the way they was moving, anything in her lap would have just fell on the ground or fell to the sides. Just moving that much, like actually moving.
Were you able to see where MaKayla's hands were during the struggle?
Just like, they just looked like they was on the side of her body almost. So I don't know if she was grabbing his arms like this, or grabbing an actual gun, or grabbing what. I just seen her hands just going like this, just putting a lot of emphasis into like trying to stop like this. She just kept going like this. So, but I'm just very far, just an arm's length away. So it's just a tussle. I just can see that she's tussling, trying to do something with her hands like this.
Am I correct that all four hands, her two and his two, are involved in this struggle?
Yes, ma'am.
And it's over one object.
Yes, ma'am.
All right, and then you hear the pop. Was that the gunshot?
Yes, ma'am.
Was there one gunshot or more than one gunshot?
Just one.
Right, and how do you react to hearing that pop? Do you know what it is immediately?
I just had to pull off.
Right, and tell us about that. How did that go?
I just remember, like, the car was smoky, like, it was actual smoke, like, the gun smoke was just, like, so vividly in the car, and I just, like, as soon as I was able to get to the main street, because I had to drive up a hill to get out the complex, I called 911 as soon as I hit the main street. The entire time, just kind of trying to, like, tell her, like, okay, we finna be straight, I'm on, you know what I'm saying, like, I'm on the phone with the police, I'm finna find the place, and, like, she said, babe, he shot me, and I'm like, where? And she say, my stomach. So even when I'm on the phone, I'm like, well, I think she shot in her stomach. And even like just from school, I'm kind of thinking like, well, you can get shot in your stomach and live for 2, 3, 4, 5 hours before you bleed out. So I'm like, we're just going to make it there. We're just going to get there. We're just going to pedal. We're going to get there. We're going to get there. We're going to get there. So it's just taking a long time to get there. I'm like, okay, we're going to go. Boom, it's people in traffic. I'm like, please let me over, because we're not in the ambulance. I'm in the truck. So I'm just like, let me over, boom. People not really trying to let me over, boom, boom, we get there. I was in traffic. I seen an officer. I was like, on the phone, they was like, try to get the police officer attention. What's the number on the back of the truck? I might can get them to help you. So I'm like, okay. I'm like, it say this number's on the back. I stopped the car in the middle of traffic, get out. I'm running to the police car. I'm trying to bang on his car. He kept going. I'm like, dang, got to get back in the car. Boom, steady going. Even when we get to the hospital. I'm sorry. But even when we get to the hospital, like, I try to help her out the car, and just from us being playful and being in a relationship, I could really pick her up, or she could pick me up. So when it came for me to just pick her up, and I'm just like, dang, this ain't right. You know what I'm saying? Like, I could tell from picking her up, I'm like, this is heavy. She's real heavy, to the point where, like, I'm stumbling. I just had to put her down, just let her lay right there and just wait for them to come.
Talked about the struggle and how all 4 hands were involved in the struggle. At any point during that struggle, did the suspect remove one of those hands and come back in the window with another object, another gun?
No, from the point that he said this is what's going to happen, and he reached in the car, he never got out of the car until I drug him with the car, and he fell, and he cracked the window and fell from being drugged. So after he put both his arms in the car, he never got out the car till I drug him, and kept going till he just had to leave. So from the point they got into it and they doing all this wrestling, they're both wrestling, both giving it, they all both going at it. It goes off, I say, dang, I pull off. Even when I pull off, he's still in the car, like, to the point where, like, his body is hanging on to the window, and I'm still pulling off. So a cool amount, as I'm going up the hill, he's dragging, his body is still dragging, so he had to let go of the car. So even after we left, he wasn't trying to let go, he wasn't trying to leave. So I think at that point he realized, oh, my gun's still in the car. So that's why you was getting drugged, because you wasn't trying to let it go, because it was in the car at the point.
And when I was asking you, could he have been wrestling with her with this hand and then come in with another hand with a gun, would you have been able to see that had he come through the window with a second gun?
I would have, but genuinely, the only reason it was toe-to-toe, because they both had both hands. If he had let one of his hands go and she was wrestling with just one of his hands, it would have took, you know what I'm saying, it would have took a turn. She would have had more strength than you had in one hand. In two. So the whole time they was going toe to toe. The whole time it was, you thought I was a woman and I'm finna be stronger than you right now, and that's all it came down to.
When you came in and said, this house is fixing to go, what did you think was happening? Was it still a drug deal at that point?
I instantly knew what it was.
What?
He wanted to take some.
You hit the gas and you describe that he's being drugged.
Mm-hmm.
Is he caught on something or is he holding on?
I can't really conclude as to whether she was holding him, he was holding her, or even if his arms was just in the window, or can't really conclude.
Okay, but he gets drugged
Yes, ma'am.
for how long? Couple feet?
Probably about 2-3 feet, couple feet, a cool like distance to where like I heard the window crack or something. Like I could hear when the window like he from his pressure like falling off. I heard the window like crack. So it could only been maybe 4 feet. He wasn't still on when I got on the main road. When I got back on the Stuckey, he wasn't on the car.
Let me show you what practice states 21. Is this the window crack that you've described?
Yes, ma'am.
Move into evidence states 21.
States 21 entered in evidence. You, of course.
So, was this how the window was when he was in it? That's a dumb question, but it wasn't rolled up like this, right?
Basically like towards to like where the bottom at, that kind of give you a good judge as to how much the window was rolled down. So to where like the bottom of the crack is at, that's about how much the window was rolled down. Yeah, that's why I stopped cracking about right there.
As far as the timing of events, I understand your testimony to be shot, fired, and then hit the gas. Is that correct, or could it have been simultaneously or something else?
Nah, because it was almost like I was in a trance, like the shot is what really pulled me out. Because again, like when they say it's fight, flight, or freeze, I was frozen. Like I'm just stuck. Like and I don't know if y'all ever heard no gunshot, but 3 feet away from you is close enough to pull anybody out of any type of thought. Because it's just out the blue. I'm like, dang, I got to do something right now.
During the struggle, did either MaKayla Bryant or the suspect say anything?
Maybe grunts, nothing like, I ain't hear no dialogue, but she was like grunting. I could tell like she was really like, she was trying.
Fighting.
Yeah,
Did you call 911?
yeah.
When did you call 911?
Maybe like as soon as I got on the Stuckey or as soon as I got on to Lake Bradford, I wasn't even 30 seconds out of the complex. As soon as I got out the complex and was able to get a phone.
And what was MaKayla's behavior like on the ride?
Aside from what she said, like she hadn't talked, but like she was trying, and it's like she was just, she just kept like not smiling, but like I could tell by the way she was breathing. Like I had never seen her breathe like that before, but like she was trying for a long time. She just was like, and she just kept like, I never seen her breathe like that, but I was like, you got it, and I could just tell like they was just getting longer. She just was like, and I'm like, you got it, but like, I don't know. I just genuinely don't. It's just,
Did she stay conscious the whole way?
nah. It kind of like, probably once I kind of got like closer towards that way, I couldn't really hear the like that. But like by the end, she was like leaned over too, like, so I couldn't really like, I'm driving for real, so I can't really do anything. I'm just kind of like touching her leg, just trying to do what I can, but just trying to drive.
Trying to let us know. All right. Have you had an opportunity to listen to the recording of the 911 call?
Just to confirm, like the beginning part was my voice.
Was that your voice?
Yes, ma'am.
Judge, at this time, I'd ask to move into evidence states 46A is the gist of the 911 call.
46A is entered in evidence.
Yes, sir. And 46B is the certification of authenticity.
Very well. 46A, 46B entered in evidence.
Permission to publish?
You may do so. I did it already. Chancellor left me a note.
911 with the alert to the emergency. TMH. Well, she didn't work that in. Okay, I can send an ambulance. Where are you? Where are you? She's going left. She's going left, but I'm gonna say I can see. St. Augustine where? You said what? St. Augustine where? Somebody's trying to stop me. Where on St. Augustine are you? Where are they going to, my basketball court, my basketball, bruh. Are you on SFU's campus? Yes, I'm on that, my kid, ma'am. Yes, ma'am. Where do I turn? I'm gonna coach you, ma'am. Oh my God! Hey. Okay, are you... Listen, are you driving? Yes, I'm driving. I'm going back. I can't watch you guys stop, man. Take a little. Like shot in the stomach. Okay, this person is driving from the hospital. Somebody got shot. I don't know where she is. She's driving. She's not stopping. Where did this happen? Where did this happen? On Stucky? Yes, ma'am. Yes, ma'am. I'm downtown. I'm passing the downtown bill. How do I get there from Monroe? I'm on Monroe right now, ma'am. You're on Monroe where? I can send you an ambulance, but you would need to pull over. Where are you? Hello? Yeah, I can't hear you. Where are you? Hold on. Where do I go? Where are you? Hello? Yes, ma'am. I'm on Monroe. Monroe where? I'm right now on Monroe. I'm passing the courthouse on Monroe. The courthouse on Monroe? Yeah, I'm passing. She's trying to get to TMH. Man, I'm just here.
We get the idea of going like that for some time, yes? You eventually get to TMH.
Gotta answer out loud.
Yes, ma'am.
You talked to us about getting to TMH and out of the car. I showed you what I marked as states 52. Is that the gun that you saw once you arrived at TMH?
Yes, ma'am.
And this gun did not belong to either you or Ms. Bryant, is that right?
Yes, ma'am.
How did this gun get into your car?
Because he dropped it after he shot her.
Introduce and publish States 52, Your Honor.
52 is entered in evidence. You may proceed.
suspects take anything from you during this? Actually get anything out of your car?
Got to get you to answer out loud.
It's okay.
He didn't take nothing tangible.
Were you able to identify either of the suspects?
The brown skin one that was further away, I just had a better, like a vantage point because he was further from the car. The dark skin one that had the face mask on, I was just struggling with his details a little bit.
Show you what I marked as states 47. Recognize this photographic lineup.
Yes, ma'am.
All right. Is this the lineup that law enforcement showed you?
Yes, ma'am.
And is this your signature here?
Yes, ma'am.
Okay, and is this the person you were able to identify here in the lineup?
Yes, ma'am.
This time I'd ask to move into evidence states 47.
States 47 is entered in evidence.
Permission to publish.
You may proceed.
All right, so this is the one that's not the shooter, correct?
Yes, ma'am.
Did you ever point your gun at either of the men during this incident?
I never touched it.
Did you ever threaten either of the men in any way?
No, ma'am.
Did Ms. Bryant point her gun at either of the men?
Absolutely not.
Did she threaten either of them?
No, ma'am.
Further questions?
Cross-examination.
Yes, sir, Your Honor.
Whenever you're ready, Mr. Prince, you may proceed.
Good afternoon, ma'am.
Good afternoon.
So, just to be absolutely clear, your testimony here today is that you went to the Special Department's on the day of the incident here with Ms. Bryant in order to conduct a drug transaction, correct?
Yes, sir.
Okay. Now, over the course of the investigation in this case, you've had multiple opportunities to talk to various folks involved in the investigation. Would that be fair to say?
Yes, sir.
Okay. So, on January 26th, the TMH, for example, you talked to two different officers, Jerome Megna with TPD and Michael Malafronte with TPD, with all the female officers.
I don't recall the names, but yes, sir.
Okay. And you gave a full interview on January 26th at TPD,
Yes, sir.
and then later they came back on January 29th and interviewed again. Is that right?
Yes, sir.
Now, when you initially spoke to law enforcement, specifically, and Officer Megna, you didn't indicate you were going to study to conduct a drug transaction. You said you were going there to meet your brother. Is that correct?
Yeah, I said I wanted to meet my brother. Then I said somebody just approached the car and started shooting. Yeah, I told one lie, and after that, I proceeded to tell the full truth about my business there.
Okay. So, was the full truth then that you had gone to study to pick Ms. Bryant up after work at the study apartment complex?
I picked her up from her job at the mall.
Did you tell specifically Michael Malafronte, or let me ask it like this, do you recall telling Officer Malafronte, or one of the male officers you spoke to, that the reason you had gone to Stuckey was not to conduct a drug transaction, but rather to pick Ms. Bryant up? Recall that?
I just told you prior to me taking accountability, saying that we were there for a drug deal, I said that it was just a random person. I didn't know why they were there. After that, I showed them text messages. They went through my phone, so that's not the story no more, the truth right now.
So I just want to be clear about the two different conversations you had with two different officers.
Yes, I've acknowledged those.
So there was one that we talked about already,
Mhm.
with Officer Magna,
Mhm.
and he was the one you said you were going to meet your brother or whatever. Right?
Yes, sir.
Okay. And there's a second conversation with the second officer, Officer Malfrante, where you say, again, not there for a drug transaction. Instead, you're there to pick up Miss Bryant because she had just gotten off work. Is that correct?
Yes, sir.
Okay, so a second ago when you said, well, that one lie and then it's all true, that wasn't exactly correct, right? Because you gave two inconsistent versions of the events before finally admitting you were there for a drug transaction. Is that fair to say?
I think being black, you just got to give yourself the benefit of the doubt. So I didn't want to necessarily for them to run with the narrative of a drug deal going bad. Instead, I kind of wanted them to just get justice in a moment for the individual herself. So that's how that was.
That's very aspirational. Well, my question is about the fact that you said a minute ago, you
Okay.
told one lie and then went to prove. That's not correct, is it? You gave two versions of the events that didn't have you conducting a drug transaction. Is that correct?
If you say so.
I'm asking you to say.
I don't recall.
You don't recall having those conversations with those officers?
Prior to the first day on the 26th, no, it was a lot of chaos. I had been crying. I had just watched somebody I was with be murdered. So no, prior to the first day, the communication probably wasn't the best or the most reliable.
Okay. So just to clarify, about 90 seconds ago, when you did say you recalled those two separate conversations with two separate officers and answered affirmatively about what you told them, are you now saying you don't recall that after all?
Sir, I recall.
You do recall?
Yes.
Okay. Do you agree that during the initial part of those conversations, you denied that you were there for a drug deal?
Yes.
Okay. And you started to allude to this. During the second conversation with Mel Bryant, is it correct that you indicated you didn't have the drug deal set up specifically, that it must have been just some random dude that rolled up on you because you were known to drive that vehicle and deal out of that vehicle? Is that right?
I don't recall that narrative.
Would it refresh your recollection if I showed you Officer Mel Bryant's report referring to that portion of this conversation?
That's fine.
You may.
Don't be out just keep that part to yourself. Highlighted portion.
That's fine.
It's page 202 of Mel Bryant's report. Having had a chance to review that portion of Officer Malfrante's report, does that refresh your recollection as to what you told him about how this assailant approached you and that he was just some random dude that must have recognized your vehicle?
Yes, sir. I lied on the first two conversations. I said that I lied. I was scared about the repercussions, so I didn't tell the truth. And I also thought she might have had a chance to come out of it, so I didn't want her to wake up in handcuffs or wake up with charges because she was involved in a drug deal.
I thought it was for justice that you lied. No? That's funny.
It's the way you're trying to misconstrue my words, but we all know the situation. That's what's funny.
So let me just stop you. I'm going to send the jury out for just a second. Remember, don't discuss the case amongst yourselves or with anyone else. Just about a 5-minute break at this time. If you need more time, you can take it, of course. Of course. All right, jury's out. Doors closed, so be seated, everyone. The reason I intervened is just to try and maintain control. So, ma'am, you are a witness, not an advocate. And what that means is you listen to the question that's asked. If it's a fair question, you answer the question that's asked. Remember, Ms. Cappleman will have a chance to ask you some more questions if she feels that there's a legal need to do that. But answer just the question that's asked. And Mr. Prince is entitled to ask you a very specific question, a question that, if it's a fair question, can be answered yes or no. Only a yes or no answer, but I can't have you arguing with him. And then, Ms. Cappleman, you said you needed a couple of minutes?
Yes, Your Honor.
All right, so witnesses under cross-examination, so you can't discuss your testimony with Ms. Cappleman at this time. Anything else before we take our break, Mr. Prince?
I just realized I forgot to invoke the rule at the beginning of the trial.
Are there witnesses in the courtroom?
Yes, sir.
No, it doesn't look like there's any witnesses, so no harm, no foul. I know that the lawyers will let me know. We got a pretty good crowd in the courtroom, so I'll have to rely on y'all to let me know who's a witness and who's not. But rule has been invoked. We're in recess 5 minutes or so. Lisa needs to stay sitting in her seat. We'll miss a prosecutor, so we'll give her a minute. Send her a text and see if she needs some more time.
I'm texting her now.
I expect maybe there's some. I know she had some. There we go. All right. So, Mr. Prince, Ms. Cappleman, anything else before we bring the jury back in? Whenever you're ready.
Jury in the court.
Thank you, folks. Come on in, find your seats. Thanks so much for your patience with us. 1, 2, 3, 4, 5, 6. All jurors are present. Please be seated, everyone. Mr. Prince, you may proceed.
Thank you, Your Honor. Okay, so we had talked about some of the initial statements you made to TPD at TMH. I want to go now to the portion of your interaction with law enforcement where you did acknowledge that there was a drug deal that was planned and all of that. I think you indicated during Ms. Cappleman's direct questioning of you that there was a text message exchange, and I think we saw some of the images of those texts where you were letting the person you were communicating with know that you had arrived at the apartment when you got there. Is that right?
Yes.
Okay. And you said that they sent a responsive text saying something to the effect they were coming out to meet you?
Yes.
Okay. They didn't come out immediately, right? It took 4 to 5 minutes?
I believe so.
I'm sorry to talk about you.
I actually just recall saying that I was outside, maybe. Like, that I was outside. I don't think I even said, like, what I was in. I might have just said I was outside or something.
And then he said something back, like, we're coming out or coming down or something like that?
I guess.
You did? Okay. And then from the time he texted you that, it was about 4 or 5 minutes before they approached your vehicle?
Probably not that long.
You don't recall that?
It wasn't that long. That's all I was saying.
If I showed you a copy of your interview from January 29th, transcript of that, regarding how long it took, did that refresh your recollection?
I believe I said something like I had like pulled off, like, and looked at the sign because I wasn't sure about the address and all that you're talking about. Yeah, I mean.
So my question is, if I showed you a transcript of what you said about how long it took for them to come out in your January 29th interview, would that refresh your recollection as to how long you said it took?
No.
That would not refresh your recollection?
No.
Okay, so to be clear, seeing a transcribed word-for-word statement of your earlier statement to law enforcement wouldn't refresh your recollection as to what you said?
No.
Okay, fair enough. All right, so at some point, though, they come out and you indicate that the main guy with you're interacting has what you call a ski mask over his face. Is that right?
I say it was like fully covering his face, like the type of thing it is. You can control, like almost like a hijab. Like you can control whether you pull it down on your chin or you pull it up this far. So, but yes.
In retrospect, now you believe he had that on because he intended to rob you. Is that what you were saying?
Yeah, probably.
Okay, and he had enough of his face covered that you would be able to identify him.
No, his lips, like, and stuff was out. But like, if you was to just see my face squished up like this, you wouldn't be able to tell my full face because you just see this much of my face squished up in the mask. That's how it looks.
Okay. So during that interaction, you observed him to wear a mask. We already talked about all the prior opportunities you had to speak to law enforcement. And all the times you've spoken to law enforcement, have you ever previously indicated that his face was obscured by any kind of face mask of any kind?
I mean, the thing I was telling you, like, it's just a hybrid type of thing. Like, you could put it on and it can stretch. You can, if you have it closed, it can only expose your eyes. If you have it pulled down further, it could expose your nose and your lips. Or,
So
you know,
I'm going to interrupt you. I'm going to interrupt you. What Mr. Prince is asking you is, did you ever tell law enforcement that he had that object on his head or face that you've just described?
Yeah, I always said that he had on this shiesty type mask or something that you didn't see 100% of his face.
Fair enough. Okay. So how much of his face then was obscured by this mask you said he was wearing?
You could see like the eyes, the nose, and some of them, like some of the lip and stuff like that.
Okay. Do you recall telling law enforcement specifically that he had gold grill?
I said he could have. No, I didn't say he had a gold grill. When they asked like how he looked, I described something like Kodak Black, like a dark-skinned dude with nappy hair. Like, no, I said he looked like he's from South Florida, you know, like a guy that wears golds and has nappy hair. I didn't say he had in golds. I said that style of person is what he looked like to me.
I got you. Okay. So, but you do recall your interview with Detective Scarborough at TPD on January 26th, what was it, 5:22 p.m.?
Yes.
Okay. And you recall during the course of that interview with Detective Scarborough indicating that suspect 1 was a 24 to 25-year-old black male, medium to dark complexion, gold mouth grill, with short wigs in his hair and wearing a black graphic t-shirt. You recall telling him that?
Yes.
Okay. All right. So you did report to law enforcement that he had a gold grill?
I guess.
Okay. All right. Now kind of moving to the interaction between you and these two individuals. You say they first approached on the passenger side, and so they would have been interacting with Ms. Bryant. Is that what you said on direct?
I just say she rolled her window down because there was more space on her thing. She necessarily like speak to them. They were still speaking to me, but it was more access on her side of the car.
Okay. And during your interaction with the two individuals, you were never able to figure out which one you were communicating with. Did you have any idea about that?
The dude who we was talking to, the brown skinned man right there, he like alluded to like, oh yeah, I'm not from out here. I seen your post on the group me. I'm not from out here. I just moved out here. I'm new out here. I just seen you on the group me. So based off of him saying I'm new out here and I seen you on the group me, he kind of took control of the situation.
I got you.
Mm-hmm.
In all of our interviews with law enforcement, have you ever told law enforcement that the individual with whom you were interacting said, I'm new here?
Yeah, I've said that before. I've said that before. Definitely, like.
All right, so he's talking to you, and you said the other guy, was it the baby-faced guy, was standing a little further back?
Mm-hmm.
You said you could see him better?
Mm-hmm.
Okay, all right. Now, at some point in this interaction, one of them gives Ms. Bryant, and maybe you can tell me which one, but one of them gives Ms. Bryant a digital scale to weigh the drugs, and she gives it to you. Is that correct?
The dark skin is the one who had all the dark skin is the only one we had any type of like words exchange. The other one kind of, I'm not gonna say he was security, but kind of like he was 3 or 4 feet back, so he never really initiated or started anything, I'll say.
So, just what I'm trying to get to right now, what I'm asking you about is the fact that they handed this digital scale to Ms. Bryant, who then handed it to you. Do you recall that?
Yes.
Okay. And obviously the purpose of that is so that the drugs you're selling can be weighed and they can verify that they're getting what they're supposed to get.
Yeah, but then like the cup never got produced, so like it was more so like you get what I'm saying? Like you're saying we're gonna use a scale and a cup, so only the scale was produced. So it's like more so like here, like just get the scale back. You didn't hand the other part, but that's when the friend came about. The friend was supposed to produce the cup.
Okay. So the cup was never produced, and it's not like you had your own cup to where you could weigh for them, right?
No.
Okay. And so they gave you the scale. Did you just end up giving the scale back to them?
No, I don't think I ever took it from her. I don't think I ever took it out of her hands because it was supposed to be, okay, if I'm supposed to hand you 2 things, like you're supposed to hand me a cup and a scale, you didn't hand both items. So it's kind of like one is useless without the other one.
So is it your testimony now that Ms. Bryant did not hand you the scale?
I didn't keep it. So whether or not I touched it and handed it back, or it was like linked like in between us, and I'm like, just get it back. I didn't keep it in my possession, is what I'm saying.
So, do you have any specific recollection of her handing it to you?
No, because the scale was never used. It was never cut on. It never weighed anything up. It was just never used.
I'm going to stop you. He's just asking you if you remember. He's not asking you why you don't remember. Go ahead, Mr. Prince. Your next question.
Yes, sir. Thank you, Your Honor. Would it refresh your recollection about whether she handed you the scale if I showed you a portion of your January 29th interview where you were asked about that?
No.
Okay, so just again to clarify, transcript word for word of your own prior statement would not refresh your recollection on that point?
No, because I have my memory.
Okay. So, but what your testimony is that you don't remember. Did I understand that right?
I just said I didn't use it. I didn't use the scale. I never had it.
Okay, that's fair enough as well. So there's some back and forth, if I understood your direct testimony correctly, about the weight, and they want it weighed, and you don't want to weigh it because you already weighed it before you came. Is that a fair summary of what the interaction was immediately following the initial contact?
Kind of, but like, again, like, he kind of pulled the money out and was kind of producing the money. So, like, does that kind of answer your question?
Okay, so he pulled money out to show you guys are you like basically still negotiating at that point?
I think everything was like written in stone. It was more so like the fidgeting with the $100, which like I had said, like, again, both people can be nervous going into it because, again, you don't know. You could think the worst of the other person too. So just once he was fidgeting with the 100, it's kind of clear, like, okay, maybe you don't have the whole 650.
Now, to be clear though, you did produce the cannabis to where that they could see you actually had the cannabis.
Yeah, I had it in my lap.
Okay. And that was the picture that we saw on direct examination. Was that like a sandwich-sized bag?
No, it was a gallon-sized bag, and I think I might have said something along the lines of like I told him, like, if you know what it is. Like, if that's what you're asking for, you know that's what it is in this Ziploc bag, basically.
Okay. So you let them see that. They were supposed to know what it was based on what it looked like. Is that right?
Yeah, like just in relation to how much was in the gallon-sized bag, because I know it looked it small, but it was really a gallon-sized bag.
And what was the gallon bag in?
A Finish Line bag.
That white Finish Line shopping bag?
Mm-hmm.
Okay. All right, and at some point, did you take out a piece of that cannabis and break it and give it to them to smell so that they could verify for themselves?
I didn't break it. I think I just took like a smaller piece, like just kind of on some, like, you can smell it, look at it, see it up close.
Did you ever end up weighing the cannabis that you were supposed to be giving them or not?
Not in front of them.
Meaning like you did before you got to the scene?
Yeah.
Okay. So while you're on scene in front of them, you never put it on the scale?
Never.
To where they could verify?
Mm-hmm.
And how did they respond to that?
I told you that's one of the gestures. That's when the cup and the scale kept coming about. When it's basically, he's like, oh, my homeboy has a cup, and if you put it on the scale and you can put one zip inside the cup, based off of how much is in the cup and how much is left in the bag, I'll be able to deduce that it is indeed 4 zips in the bag. So just basically like a big math problem, essentially.
Will you tell me what a zip is so they can follow?
I'm sorry, 28 grams. So he was essentially wanting 4 of this unit. So he was saying that if his friend could see 1/4 of it, that he would indeed know that it was 4 more parts to it, if that's making sense. Like.
And that's an ounce, right? So they wanted to see 1 of the 4 ounces, basically. Is that what you're saying?
Yeah, like if I brought him $1, they wanted just to see a quarter, like just 1/4, and I still have the other 3 over here, so they would at least know, like, that's the quarter, those are the other 3, basically.
Okay. And tell me if I'm right about what I heard you say on direct. Did you indicate that they never asked to get into the back seat so that they could see you weigh it?
No, they didn't.
Okay. Do you recall on your January 22nd interview with Detective Scarborough at Tallahassee Police Department telling law enforcement that when they asked you to weigh
The 22nd.
The 22nd, right? So the first full-length interview at TBD?
The 22nd.
Oh, I'm sorry, probably about 26. That's my fault. I'm sorry about that.
Okay.
26, your first full-length interview at TBD. You recall talking to Detective Scarborough there, correct?
Yes.
Okay. And do you recall explaining to Detective Scarborough in the course of that conversation that they didn't think it looked like a quarter pound? You reassured them that it was a quarter pound, and that the suspect asked if he could sit in the back seat and weigh the marijuana, to which you replied no.
I don't recall him asking to sit or what. I mean, I just recall them asking for me to weigh it. So, but I don't whether or not he asked to get in, I probably would have shot that down either way, because like couldn't nobody get in the car. But I just remember it just being an emphasis on them wanting me to weigh it.
So let me stop you. The question is not that. The question is, do you remember talking to law enforcement about them getting in the back seat of the car?
No, I don't. I wouldn't let nobody in the car, so I just don't remember saying. If he did ask me, I don't remember, but I just know nobody got in the car, and that wasn't part of the discussion.
Would it refresh your recollection about what you told law enforcement relative to the individuals asking to get into your vehicle by letting you see that portion of Detective Scarborough's report? That's enough?
Yes.
Okay, good enough.
I just, this is all I'm saying. I don't want to read something and say, oh, now I remember.
So here's the thing. You do not need to wonder about why Mr. Prince is asking you the question.
Mm-hmm.
The only question that he's asking you is, would it help you remember when you talked to law enforcement, whenever it was, about
2 years ago.
2 years ago. So would it help you remember to look at it if what you said? If you looked at your transcript?
As he's asking me, can I have the same copy that he has?
Yes.
Okay, we can do that then.
Go ahead.
Will refresh your recollection?
Yes.
All right, have press witness here?
Go ahead, Mr. Prince.
Starts on page 5.
To clarify, he's asked the witness if reviewing Scarborough's report would refresh your.
Oh, this is not the transcript?
No, this is Scarborough's report, that's correct.
All right, so take a look at the report and see if it helps you remember.
Having had a chance to review that selection I was talking about on page 5, going on to page 6 of Detective Scarborough's report, did that refresh your recollection?
Mm-hmm.
Now, having had a chance to review that, do you recall telling law enforcement that the individual did ask to get in the back seat of your vehicle to weigh it, and you indicated no?
Yes.
Okay. So on direct examination, when Ms. Cappleman asked you that question directly, and you said no, that didn't happen, that wasn't correct, right?
Again, it's been 2 years, so some things are cloudy.
Okay. All right. Do you recall that as they were asking to weigh it and all that, you wanted them to give you the money first, and then you were going to let them weigh it themselves? Do you recall that?
Yeah, like I think once it started coming about that however much would fit in the cup, yeah, it was like, well, you know, once you pay it, you could do whatever you want with it.
Okay.
Mm-hmm.
So it was at that point that the other guy went to get the cup. Is that right?
Yeah.
Quote unquote, get the cup.
Yeah.
All right. And was it when he goes to get the cup that you are looking down at your phone, or was that later?
Yeah, like he kind of makes. I'm not gonna say I saw him walk away because like the angle, but like as he makes a gesture to kind of leave, that's when I momentarily like just check my phone. Like this is just a time for me to look down at the phone essentially.
Did you get like a call or text or something?
No, it was more so like, okay, well it's gonna take him. How he's indicating he's gonna walk upstairs and get the cup and stuff like this. So it's like to me, I'm like, okay, this might take a couple seconds. You know, so like just check my phone, just a natural instinct to just check your phone, basically.
Did they have that skill when they walked up initially, or did they like have to go back and get that at some point?
I mean, he never left from by the car, like, so you hear what I'm saying? Probably was in his pocket already with the wallet too, because like I said, like it went from being a wallet, pulling $100 bill like this, then it went to boom, now the scale popped out. So now I don't see the wallet anymore, now I see the scale now. the scale then came out and the wallet's back in the pocket or whatever.
Do you recall whether either of them had to go back to get the scale, or did they have that the entire time as far as you recall?
As far as I recall, they had it the whole time, and like, yeah.
All right. Okay. So you indicate at that point you're looking down at your phone, correct?
Yeah, just for a little bit. Mm.
All right. And while you're looking down at your phone, do I understand you correctly that kind of out of the corner of your eye, you see the suspect reach in, and when you actually look over to see what's going on, you see the suspect and Ms. Bryant wrestling over the gun, as you've indicated, 4 hands on the gun, they're wrestling over it, is that right?
Well, his voice got my attention when he said, this how this finna go. That's what got my attention from my phone.
Okay. And so when he says, this is how this figuring to go, he doesn't say, I'm robbing you. He doesn't say, give me your money, give me your guns, give me your weed. He doesn't say, give you any other directions. It's just, this is how this figuring to go. He reaches in, and now he's wrestling.
I told you, it was a change of tone, a change of demeanor. If you went from just saying like, hey, da-da-da, to, oh, this was going to happen. You know, it would kind of shake you to your core, like this person's, now you're being aggressive with it. So that's, yeah.
But just to be clear, it's not, this is what's figuring to happen. I'm going to take your drugs, I'm going to take your guns, I'm going to take your money. He doesn't give any of those directions, just this is what's figuring to happen.
I mean,
That's what he said. Is that what you're saying?
yes, the rest of it was, you know, like the nonverbal communication.
Okay, fair enough. And you don't actually see what happens in that, like, 1 or 2 seconds between where he says that and when they're wrestling. Like, you don't see that specific instant during this interaction. Is that correct? Because your eyes hadn't diverted to the right yet?
Yeah, like if you're saying like if I seen like him put his arm in the car, no. By the time he said this was going to happen and I looked over, his arm was already in the car. So again, it was kind of like it is a 2-3 second relay where I can't say like I was looking at it because I had looked down.
Okay. So because you're not looking that way and you're looking down, you can't offer any testimony one way or the other about whether Ms. Bryant raised the firearm when he reached into the vehicle. You weren't looking, so you can't say that, can you?
I can't like 100% say like just from being with somebody for 4 years, I know she didn't lift the gun for no reason. So I can attest to that truthfully 100%.
So, but your statement about that is based on her character as you see it, not
Yes.
based on anything you observe.
Yes.
Right? So you have no firsthand knowledge of exactly what happened right there because you weren't looking.
Yes.
Okay. But when you do look over, they're wrestling with a gun, right?
I know that once he stuck his hand in the car and they was fighting, his hands didn't leave the car until he fell off the car. So until he fell from the car, his hands was totally involved in the altercation the whole time until he got dragged off the car.
And do I understand your testimony correctly that the window is only half down at this point?
I mean, I can't sit up and say what percent, but yeah, it wasn't fully down.
Okay. But not like all the way up to where only his hands are stuck in there. It's some distance down.
At least like how I looked on the picture, I would pay maybe at least halfway down. It was halfway down.
Okay. And how did the window get broken?
His body was dragging on it like a pressure crack.
Right. Do you know why there are pressure cracks at those 2 specific points on the window?
Because one arm was like this and maybe one arm was like that.
Okay. And so his full body weight's on the window at that point.
Yes.
And the window doesn't break.
It does. When I pull off, it breaks because of his body weight.
I mean, it doesn't shatter. It pressure cracks. It doesn't shatter with his full weight on it.
I mean, it's...
At any point, did you turn to put the power window up during them fighting over the firearm?
No.
No. So the window was, like you said,
Like, yeah,
roughly halfway.
yeah, wherever it was stayed at, like wherever it was at when it started, it ended right there too. It was no moving the windows or nothing.
Okay, all right. Okay. Ms. Cappleman asked you several questions about this, and I just want to be as clear as possible. So, you indicated that what snapped you out of kind of your shock over them fighting over the gun was the fact that the gun discharged. And that's when you hit the gas and took off. Is that correct?
Yes, sir.
Okay. Do you recall during your January 29th interview with law enforcement, and for reference, this is page 11, lines 4 to 10. You recall during your January 29th interview with law enforcement indicating that you feel bad too because you didn't hear the shot until you hit the brake, like until you hit the gas so hard, and it just like yanked off, and at the same time, like, pow, that's the noise. And you grabbed it probably like 2 to 3 feet. You recall that?
I recall saying it.
Okay. So today, your sworn testimony is the gunshot snapped you out of it, and then you hammered the accelerator. Correct? Back then, when you were talking to law enforcement on January 29th, you said you felt bad because you slamming the accelerator yanked the car forward, and that's when the gun discharged. Is that correct?
I've had 2 years to pray and think and analyze and have therapy and really, acknowledge what happened. So I'm 100% sure I know what happened that day.
So your memory is better now than it was a couple of days after it happened?
That's what happens when you have PTSD from an experience.
Okay. So I also wanted to clarify, you indicated on direct initially that he hung on for a long time because he was trying to get his gun back. He dragged him all the way up the hill, and then the Cappleman kind of came back and asked you, he said 2 or 3 feet. So can you clarify that? Was it 2 or 3 feet, or is it all the way back up that hill that he pulled on your vehicle?
It's not all the way up. It's like, it's hard to tell, like, with it being at an incline and it going, like, it could have been 3 feet, it could have been 5, but it wasn't, you get what I'm saying? It wasn't onto the main road. I know at least by the time I was on the main road, he wasn't on the car. So again, I can't tell you exactly how many feet because it's an incline, but he was drugged for a portion. He did break the window with his body for a portion and then, fell off.
Okay. Suffice it to say, it's 2 feet, it's 3 feet, it's 4, it's 6, it's 8. It's not 40, 50 feet like that.
Yeah, no, it's not no football field or nothing.
Okay, all right. And just to clarify, I think this was implicit from your testimony, but at any point during this entire interaction, were there other people around out there, or did you not see anybody else?
It's more so one of them, like, I wasn't specifically like, I see somebody that I remember, but, it could have been people walking by on the streets, or it could have been people walking in and out their apartment doors, but I wasn't looking at them. I kind of was trying to handle my situation right then.
I got you. Is it fair to say that that's a pretty busy area, people coming and going all the time?
Yeah, and I mean, like, we was bagged in, so it was a whole building that I did not see. So if it was anybody behind me, I wouldn't have been able to tell what they had going on.
Okay. All right. And before, when you were answering questions about maybe this guy recognized your vehicle because you're known to deal out of that vehicle, had you previously dealt with that specific apartment complex before?
No, that was something else that I meant. But yeah, no, this misunderstanding, like a miscommunication. I hadn't been on that exact one, but Stuckey turns into FAMU Way, so of course, like it being near campus, I've been in a general area before.
Okay. And this is about the last thing here, but did I understand your direct testimony correctly that it was when you saw the third firearm, the Glock, in the vehicle at TMH upon arriving, that's when you realized that the gun that they must have been fighting over was his gun, not the gun that Miss Bryant had in her possession? Yeah,
because again, I didn't, like I said, I didn't see him I didn't see his gun, I didn't see all of that. So I'm thinking, this is all speculation. I'm like, oh, he didn't try to reach in and this happened. So it wasn't until I opened the door and I'm able to really observe both of our firearms were underneath the seats in the back seat. It was only one that I noticed on the floor right by where her feet would have been at.
Okay. And when you saw that other gun in the TMH, that was before you spoke to any of the officers, correct?
Yes.
Okay. And do you recall when you were talking to law enforcement eventually, this during the January 29th interview, that you suggested maybe they should test her gun, the one that she was holding, for DNA, because you thought initially it was that one that they were wrestling over?
I told them to test the whole car because I had cleaned the car. So I said, if y'all want to take DNA from anything, y'all could pull it from anything.
So I'm asking specifically about that gun. Do you recall telling them during that January 29th interview, so I thought he grabbed it, maybe you all want to check that too? Do you recall that?
Yeah.
Okay, so that was specific to the gun?
I mean, it wouldn't hurt to check the gun either, even if it was another one. It wouldn't hurt to just really check for DNA. I was just telling them, y'all could check. I just cleaned the car out this morning. I went to the car wash. So I said, y'all can pull all the DNA you want from anything, because if it's not mine, it's not hers, it's going to be his. That's it.
And the reason you said that was because you thought he grabbed her gun, right?
Yes.
Okay.
Even after, but again, when you could see, like, on their body cams, when they got to the actual hospital, I was like, look in there, look in there.
You have answered Mr. Prince's question. Mr. Prince, your next question.
Thank you. So this is what I wanted to clarify. You indicated just a minute ago here that once you saw the gun in the vehicle, before talking to law enforcement on January 26th, you realized it was the Glock they were fighting over, not Ms. Bryant's gun. But now you've acknowledged on January 29th, 3 days later, you're telling me to test Ms. Bryant's gun because his DNA may be on it.
Yes.
If they were only wrestling over his gun, how would his DNA be on her gun?
They're trying to solve a crime. Shouldn't they test everything?
Well, you were there.
That's all I suggested.
I'm asking this question is it your testimony today that they did not wrestle over Ms. Bryant's gun? Or can you not say? And if you can't say, that's fine too.
Okay, I'm, like I said, the angle that it was at and how it was, I cannot 100% tell you one black Glock from another black Glock. No, I can't.
And that's perfectly fair. At any point, either before arriving at the hospital or after arriving at the hospital, did you see what had happened to Ms. Bryant's gun and the gun, your gun, the gun she was in possession of?
No.
So that was just then wherever she dropped it. It wasn't stashed or tucked anywhere?
No, everything was there in the car, basically.
Thank you, ma'am. I don't have any questions.
Redirect Ms. Cappleman.
There was a cup and a scale found in the inventory of your vehicle. Is that your stuff pictured in States 35?
Yeah, it's my little lunchbox and stuff.
Okay.
Is it 35, is it 35 or 36?
This is 35.
All right, fair enough. I'm showing on the list it's 36, but I think I'm showing on the list.
This should be inside the lunchbox, so the items are still inside.
All right, fair enough. So 35 and 36.
Published.
You may proceed. 35 and 36 are entered in evidence.
While that's warming up, I'm going to also show you States 55. Is 55 something that belongs to you?
No.
Okay. Was this scale something that was left in your vehicle by the suspects?
Yeah, this the one this is his that I was supposed to put the cup on and show them that it was at least a zip in the cup.
All right. So the one on the picture that's being displayed right now, that's your scale that was in your lunchbox. Is that right?
Yes, ma'am.
Okay. And did that ever come out or come into play at all during the drug deal that we're here about?
Nah, because, like I said, around the corner I had weighed everything up. So all I would have had in my lap was what I needed, and the rest of that stuff was like in the back or in the trunk.
All right, Judge, at this time, I ask to move into evidence States 55.
55 is entered in evidence.
So this scale pictured or in person here at States 55 is the only scale that was involved in this incident that we're here about. Is that right?
Mm-hmm.
Is that yes?
Yes, ma'am.
Any further questions?
All right, so you may step down. Thank you so much for your time. Let me just get Mr. Prince and Ms. Cappleman to approach this briefly. We don't need to be on the record.
I'm sorry, we just spoke about the-
We do not need to be on the record, sorry. All right, so members of the jury, it's a long story, but we're going to try and go. We're going to stop by 6 p.m. It's a little later than we would typically go. The good news is we'll make up time tomorrow, of course, but my apologies. It's a human process, and we've got to accommodate the witnesses. Does that cause anybody any emergencies at this moment that you need to communicate with anybody about? Seeing no takers, Ms. Cappleman, your next witness.
State calls Rodriguez Bryant.
All right. Mr. Basanth? Mr. Basanth, you come on up here to me. You're going to come on straight up here to me, and I'll swear you in and we'll take your testimony. Thank you, sir. Come right up here. All right. How you doing? Doing well. Why don't you go ahead and raise your right hand for me?
All right. Facing you.
That'd be fine.
Okay.
Do you solemnly swear or affirm the testimony you shall give in this cause shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Very well. Please be seated. Ms. Cappleman, when you and Mr. Basanth are ready, you may proceed.
Thank you, sir. What is your name, sir?
My name is Rodrigue Basanth.
Will you spell that, please?
Rodrigue is the first name, and the last name is Bissainthe.
How are you employed, sir?
I am a sales associate, and I'm currently also employed in healthcare.
And where were you living back in January of 2022?
Providence Point, 1242 Stuckey Avenue.
And was your apartment downstairs apartment or upstairs?
Second floor, upstairs.
Okay. Were you at home on January 26th of that?
One more time? One more time, please.
January 26th, 2022, the incident that we're here about today.
Mm-hmm.
Were you home that?
Yes, I was.
And did you see the vehicles that were involved in the case that we're here about?
Yes.
All right. Was there a vehicle that had two ladies in it?
Yes.
What type of vehicle was that?
It was a SUV gray.
And was that vehicle parked in one of the parking spots there at the apartment complex?
Mm-hmm.
Was it pulled in face forward
No.
or back?
Back.
Okay. And was it, if the parking lot's kind of a T shape, is it the base of the T or the top of the T?
It
That
depends.
was a terrible question.
Yeah.
Your own words. Where was it?
It was. I mean, it was right across from my door, really.
All right. Did you observe two men approach the car?
Yes.
Okay. Can you describe what type of clothing they have?
From what I can recall, someone just had a gray hoodie on. That's it. That's all I can recall.
Did you have an opportunity to review the statements you gave back on January 26th of 2022?
No, I have not.
Okay. Did you, in that statement with Detective Collins, indicate that one of the subjects had on a mask?
Yeah.
Okay. You
Mm-hmm.
remember that? Did you see one of these men hand a small black box to one of the women in the car?
No, I did see him walking towards the car with it.
Okay, but you didn't see it get handed off?
No.
And do you know whether it was the one in the mask or the other one that had the black box?
No, I couldn't tell you all of that.
Did you ever see the occupants, the ladies in the silver SUV, did you ever see them get out of the
No.
car?
No.
And did you watch this whole situation, or did you just observe them having a conversation and then went about your business?
I just kind of, glanced back and forth because of how my couch was situated. If I happen to sit on the couch and I turn to the left, I'm looking straight outside. So I was taking an exam, an honor lock. So
Yes.
as I was doing my thing, I could glance out.
Was there anything that was alarming to you about the situation?
Not at all.
Okay, and so the conversation between the parties seemed to be civil or friendly?
Yeah, definitely.
Did you at any point overhear any argument?
No.
Okay, did you hear a noise that did get your attention at
Yes.
some point? And what was that?
It was a pop sound.
Okay, and when you hear the pop sound, was it one pop or more than one?
Just one.
Okay, and And do you know how long after you observed that small black box that you heard the pop sound?
I couldn't tell you.
And did you see the silver SUV leave the parking lot after hearing the pop sound?
Yeah, I heard it leave, yeah. So as I heard it leave, I kind of glanced again, and I just saw the rear end of the vehicle leaving out.
And did it leave out of there in a hurry?
Yes.
What did the two men do after the silver SUV left in a hurry?
From where I was, I then sat up. Then I walked towards the door, and looking across, they were just standing there casually.
Right. So they didn't seem freaked out, upset?
Not at all.
Did they run anywhere?
No.
What did they do?
They just walked back to their car.
And did they leave in their car?
Yes.
And was that, you said 5 minutes later, about 5 minutes later, you see their car leave?
Yep.
And what type of car was that?
Color was green. I could tell you that much.
Was the car leaving in a hurry similarly to how the silver
No.
vehicle left?
No.
So the second car, the green car, just left normally? Were you able to see which direction either car turned out of when they left the study complex?
No.
No further questions?
Cross-examination.
I just wanted to clarify one thing, sir. So as you were describing the individuals walking, two male individuals walking towards the silver SUV that you saw, did you characterize, or would you characterize there as being anything suspicious about them, or the way they were approaching, or anything at all about their behavior from your vantage point?
No.
And you shared that with law enforcement when they asked you about it?
Yes.
Way back in 2022?
It depends on what was said, so.
Okay, you just don't recall that?
Yeah.
But as you're sitting here today, you can testify based on your own recollection that there wasn't anything suspicious, and in fact, you thought they probably knew each other? Is that
Yeah.
right?
Uh-huh.
Okay. All right, I don't have any other questions. Thank you.
Thank you, sir, for your time. You may step down.
All right.
State calls Alyssa Feller.
All right, thank you, ma'am. Come on up and have a seat next to me. Once you sit down, I'll swear you and we'll take your testimony. Please be seated. All right, turn towards me when you're ready. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you shall give in this cause shall be the truth, the whole truth, and nothing but the truth?
Yes.
When you and the witness are ready.
Will you please say your name and spell your name?
Yes, my name's Alyssa Feller, A-L-Y-S-S-A, last name Feller, F as in Frank, E-L-L-E-R.
How are you employed, ma'am?
I was a former employee of the Tallahassee Police Department, a forensic specialist.
Okay. How long were you employed as a forensic specialist?
Roughly 2 years.
And is that what you were doing back in January of 22?
Yes.
What do forensic specialists do?
They document, collect, and preserve physical evidence at crime scenes.
And as part of your duties as a forensic specialist, did you process the silver Lexus shown in the state's exhibit 20? Show you this one. This vehicle here.
Yes, I did.
So where was that vehicle processed?
At the Tallahassee Memorial Hospital.
And when you arrived at TMH, had some firearms been secured out of this vehicle by a law enforcement officer there?
Yes.
And were you responsible for impounding those items, taking them into evidence?
Yes.
I'm going to show you state's exhibits 49, 52, 53, and 54. We'll start with 53. to identify this item as one of the firearms that you collected from the law enforcement officer that was there?
Yes, that's my handwriting on the evidence tape.
Okay, and as far as this gun and the other 2 weapons that you impounded, would we need to talk to that officer to know exactly where in the vehicle these guns were located, or is that something that you documented?
No, that's not something I would document.
You would talk to him about that?
Yes.
Okay, in reference to this specific firearm, State's Exhibit 52, was there a casing associated with this firearm? You can take a look at the original package. Was there a casing associated with that particular firearm that was collected by you?
Yes.
And what is a casing?
A casing is a fired round, so it's hollow, so you know that it has been shot by a firearm.
And is a casing something that is typically ejected by a firearm like this when the gun is deployed?
Yes. Yes.
Okay. I'm going to show you State's Exhibit 54. You recognize State's 54?
Yes, I do.
And what is State's 54?
A fired cartridge casing.
Okay, casing from where?
Collected from item 14.
And what is item 14?
This Glock 17 right here.
Thank you. And in your processing of this crime scene and the weapons that were associated with this vehicle, were any other spent casings collected other than that one?
No.
Did you locate any cannabis or cannabis-related items in your processing of this vehicle?
I did.
I'm going to approach and show you some photographs. I think I've got 22 through 38, 42 through 44. We'll start with those.
Did you say 22 through 28?
22 through 38.
38.
42 and 44 is what I'm showing.
35 and 36 already in evidence.
So just take a moment to look through these photographs and let me know when you're done.
Okay.
Judge, while she's doing that, may I publish State's 54?
You may.
May I hand this to the jury and let them pass it?
Yeah, so publish just means show it to you. You may look at the item briefly at this time. Other than firearms, everything else that's entered in evidence will go back to the jury room with you, so you need only look at it briefly at this time.
Ms. Feller, are these all fair and accurate photos of the crime scene that you processed?
Yes.
Judge, at this time, I'd ask to move those items into evidence.
22 through 38 entered in evidence. 42 through 44 entered in evidence.
May I publish?
You may, of course.
Starting with State's Exhibit 22, were these 2 backpacks taken out of the vehicle?
Yes.
And do you know from where in the vehicle the backpacks were removed?
I'm not sure where.
Okay, would you have been the person that physically removed them, or would they have already been out when you got there?
They were already out when I got there. I did.
State's Exhibit 24. We're looking inside the pocket. Did you take this black pouch out of the pocket?
I did.
State's 25. Is that black pouch?
Yes.
And State's 26. What was inside the black pouch?
It looked like gold teeth.
State's Exhibit 27. Is this another pocket of that hand backpack?
Yes.
And what are we seeing here?
A bag of suspected cannabis. Yeah.
State's Exhibit 28, is that the cannabis you're referencing?
Yes.
And this is separate from the cannabis that we're going to see in the white finish line bag.
Correct.
And at the bottom of that tan backpack, was there some U.S. currency?
Yes.
How much money was there?
I don't recall on the top of my head. Can I look at my report? There was $479.
And State's Exhibit 30, what does this show?
A magazine.
And what's a magazine?
You put inside a firearm. It holds cartridges.
State's Exhibit 31, so this is the item that holds the ammunition.
Yes.
Did you also search for Ray's backpack here in State's 32?
I did.
Inside the Ray's backpack, did you locate an Adidas lunchbox, State's 33?
Yes.
Did you look inside the Adidas lunchbox?
I did.
And publishing State's 36, was this scale and cup located inside that lunchbox?
Yes.
Was there any cannabis located inside the lunchbox?
I believe so, yes.
State's 37. Publishing State's 38. Again, these items are separate from what was in the hand backpack initially and also the white finish line bag, is that right?
Correct.
And then the white finish line bag shown here in State's Exhibit 42. And also State's 43. Is this just a view looking down into that bag?
Yes.
I wanted to show you State's Exhibit 55 as well. This is already in evidence on a digital scale. Are you able to tell the jury from where within the vehicle that scale is located?
I can't recall out of the top of my head.
Would you be able to look at something to refresh your recollection?
Yes, can I look at my report?
Yes.
Okay. The digital scale was found with the backpacks and everything before I got to the scene.
Okay, so it was removed from the vehicle prior to your arrival?
Yes. I did.
States 50 and 51. Do you recognize these exhibits?
I do.
Are these the items shown in the photograph?
Yes.
And you impounded them on that date?
Yes.
Okay. Judge, at this time I'd ask to move into evidence 50 and 51.
States 50 and 51 entered in evidence.
And lastly, I have photos 39, 40, and 41. I know I showed you at least one or two of the firearms that were collected, but did you photograph the firearms that were collected at the scene?
I did.
And are these fair and accurate photos of those firearms?
Yes.
Judge, I'd ask to introduce those exhibits.
39, 40, and 41 entered in evidence.
And I have 1 moment to check my notes.
One moment you shall have.
Nothing further, Your Honor.
Cross-examination?
No, Your Honor.
Thank you for your time. You may step down. Any other witnesses or other evidence at this time, Ms. Cappleman?
Yes, Your Honor. The state has one additional witness for today, Officer Derek Pearson.
Whenever you're ready. I think I'll turn the air conditioner off. Start to feel a little warm in here again. Warm? Yeah, you feel warm? Yeah. All right, Officer Pearson, come on up and have a seat next to me. Thank you, sir. Come on up and I'll swear you in and we'll take your testimony. All right. Yeah, that'd be fine. Get comfortable. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you shall give in this cause shall be the truth, the whole truth, and nothing but the truth?
I do.
Very well. When you and the witness are ready, wherever is there, Ms. Cappleman's over there. When Ms. Cappleman's ready, you may proceed.
Please introduce yourself and spell your name.
My name is Officer Derek Pearson, Sr., DERRICK PEARSON, Sr.
And are you employed at the Tallahassee Police Department?
Yes, ma'am.
How long have you been there?
A little over 7 years.
And did you respond out to the Tallahassee Memorial Hospital on January 2nd?
20.
January 26, 2022?
Yes.
And did you secure a Lexus SUV in which the victim in this case was transported to the hospital?
Yes, ma'am.
And as part of your securing that vehicle, did you secure some firearms within that vehicle?
Yes.
How many firearms?
A total of 3.
Okay, are you able to tell the jury where each firearm was located within the vehicle?
Yes, the Glock 17, which was the suspect's gun, it was located in the front passenger seat floorboard.
Stop there. Front passenger floorboard. Okay, is that this weapon here that's got the sticker on it?
Yes.
Okay. And when you located the weapon, did you do anything to try to make it safe?
Yes, I brought it back to the rear of my patrol vehicle, and I locked the lever to the rear, and a spent casing ejected.
Okay. Doesn't a spent casing typically eject at the time the weapon is fired?
Yes.
Why would a spent casing still be in the gun when you went to clear it that it had been fired already?
The gun had already been fired.
Right, but why was the casing still inside the gun?
I can't really say why it was still in there.
Okay, could it have been jammed inside the gun?
It's possible.
All right, so when you cleared it, obviously you didn't fire a projectile.
Right.
Okay, but the casing did come out indicating that the gun had been fired, is that right?
Yes.
Okay. And that casing was turned over to the crime scene folks to impound?
Yes.
Okay. All right, let's move on to the second gun. Let's do the Springfield XD. Do you know from where in the vehicle this weapon was located?
The Springfield was located on the passenger side.
On the passenger side, okay. Do you know where exactly?
In between the B pillar of the door and the passenger seat, it was stashed at the bottom.
All right, and the B pillar, is that where the seatbelt comes out of?
Right.
And what about this third weapon? This one is a Taurus G2C 9mm. Do you know where in the vehicle this weapon was recovered?
That was recovered on the driver's side, in between the B pillar and the driver's seat.
No further questions?
Cross-examination.
No, Your Honor.
Thank you, sir, for your time. You may step down. Is that the last witness for the day?
Yes, sir. Thank you.
Anything else? Anything else before I send the jury home?
Nothing from the state.
Thank you so much for your patience. Remember, don't discuss the case amongst yourselves or with anyone else. Be back here tomorrow at 8:30. We'll start promptly. Be respectful of your time. Thank you so much. 8:30 tomorrow. 8:30, 8:30, 8:30.
I guess since we're going to get testimony tomorrow, so I'll go by the office and bring a blue shirt and tie to with that. Okay. Sorry about that.
Do we need to be here at 8:30 or are we starting at 8:30?
Be here at 8:30. Be here at 8:30.
Thank you.
Oh, jury's out, doors closed. So, Ms. Cappleman, give me some idea what the day's going to look like tomorrow.
I have 1 to 2 remaining witnesses.
All right, and Mr. Prince, it sounded like there is likely to be a defense case?
Yes, sir. It'll be the defendant and Mr. Knight. I don't anticipate either of their, at least for the direct portion, being very long, maybe 20 minutes each, maybe less.
All right, fair enough. So, Mr. Oglivie, you have every right to testify on your own behalf if you choose to do so, as Mr. Prince has indicated.
Yes, sir.
I want you to understand that I can't force you to testify, and Mr. Prince can't force you to testify. You have to make that decision for yourself. If you choose to testify, you'll be subject to the same cross-examination as every other witness in the case, and I'll instruct the jury to consider your testimony using the same principles as all of the other witnesses. You've already heard the right to silence instruction, but it's up to you to decide to testify. Do you understand that?
Yes, sir.
All right. If you change your mind, and you can, if you change your mind, let Mr. Prince know, let me know. If you take the witness stand, I will assume that it's your decision to testify.
Yes, sir.
Are there any questions you want to ask me about that decision?
No, Your Honor.
Have you had enough time to talk with Mr. Prince about it?
Yes, Your Honor.
And, all right, and so tell me what your decision is at this point.
I'll testify.
All right, very good. As far, you can sit down. Got a little bit more, tiny bit more work to do. Has either one of you had a chance to spend any time with the jury instructions at this
I
point?
have not, Your Honor, but we'll have Mr. Evans looking at them, so hopefully I'll be prepared to work on them tomorrow.
All right, I'm not putting any pressure on you. I just wanted to know if there's anything you wanted me to work on tonight, Mr. Prince.
Usually what I do, because it's so specific, is just draft the justifiable use of force instruction and then give it to both.
I've got an instruction for your consideration, but I have no pride of authorship, so that's absolutely fine. If it helps, it helps. If it doesn't help, we'll work off your draft, but that's fine. So we'll start. So here's my working hypothesis, is that we'll probably, if things go the way you're describing, take a relatively early lunch and do a charge conference tomorrow and see if, tomorrow at or around lunchtime, and see where we get from there. We have a little bit of luxury of time now. So anyway, that's my working hypothesis.
Sounds good, Your Honor.
Thank you, folks. See you tomorrow.